entitled to this irrigation.
35.
Yes. The concerned advocate for the petitioner is out of station due to some personal difficulties.
Okay, you're taking consent of the other side. You're for petitioner. Okay, consent of the other side. Counsel for the petitioner pays for adjournment. There is allowed list after a week. After a week.
Item number 34.
Yes, personal appearance. Item 34.
Daily list item number 1 for Muslim.
May I please,
Yes,
on last revision, respondents are directed to take instruction.
My lord, we have wrote a letter, my lord. We have written a letter,
there
my
have been in
lord.
fact no instructions.
we have
The petitioner was the petitioner's father was it was a personal post.
So,
Personal post itself will not create a right.
against the personal post, my lord, nobody can be appointed. Personal post is whenever.
No. The question is whether a compassionate appointment can be considered. That is the only legal issue.
A notice may be issued, my lord. I
Okay.
will-
Because that is the only point, whether the person who has been appointed on a personal post. Because you see, muster roll workers,
Yes.
they are regularized in a personal post.
Against,
After that to give their dependents compassionate appointment, that would be something not,
compassionate
as per the
appointment, my lord,
scheme.
so far my knowledge goes, my lord, against the sanction post and existing post, my lord. Personal post is come to an end when the person is superannuated, my lord. So against those, I will obtain instruction, my lord, in this regard specifically. At least the notice may issue, my lord.
okay. Both sides are duly represented. I'll just give him name, Miss
You have written.
U. Hazarika for the petitioner and Mr. P.C. Chityal and additional senior government advocate appearing for the respondents.
1
Yes,
and
madam.
4, my lord.
1 and
4,
4.
others PWD departments.
Who's for?
PWD.
Others are PWD.
PWD.
Okay. PWD will be there.
The names are shown, my lord.
Name is not there, no? PWD, Mr.
P. Nair.
P. Nayak, Mr. Nayak has
Nayak.
come.
No, but एक तो मतलब. Sorry. Yes. Lord.
You're
I'm
there?
preparing notice to the
Okay. Mr. P. Nayak, standing counsel for PWD,
2, 3, 5.
appearing for respondent numbers 2, 3, 5, 6, and 7.
Yes, yes.
If you notice a motion returnable in 4 weeks, requisite extra copies of the petition will be served on the landed state and department council in course of the day. List on swells. Mr. Nayak, what is the law on the point? Personal posts, can there be a compassionate appointment?
Lordship, if it is appointed, going by the schemes of 83, that started in 83 Lordship, then it has to be. a
That is the
regular
only
post.
point involved here.
Yes, Lordship. A compassionate appointment always has to be maintained a regular post. Existing.
No, but what happens if the government regularizes them in a personal post?
No, if it is compassionate appointment, Lordship, there is no question of regularizing Lordship. It has to be in a regular post.
Personal post.
No. The question is, somebody is appointed in a personal post.
Yes.
He dies.
No, it is not possible. In the scheme itself,
No.
it is mentioned. Lordship.
Is it there?
Yes, in 2015.
That is the
scheme,
only point here.
It is there, Lordship. In 2015 scheme, it is.
That is the only point involved here.
Yes, sir.
Only one dependent,
Member of government servant.
serial number 1, Lordship.
regular basis. Servant appointed on a regular basis.
Excluding one working on daily wage
Or casual. Appointed or ad hoc or contact or re-employment basis. Without the address. Becoming the particular.
No, because here what has happened, he is no longer, after the service is regularized in a personal post, he is no longer daily work, daily wage earner or casual or apprentice. He loses that,
the regular. Also, that point I will.
only that is the only issue here. He has been regularized.
Online.
That is Lordship,
Yes.
the matter has been influxed.
Infectious.
Yes, he has been reinstated.
Huh?
He has been reinstated.
Okay. Mr.
Be secure.
Counsel for the petitioner submits that the petitioner has been reinstated and therefore matter has become infectious. Mr. T.C. Chidiyal, and the additional senior government advocate is present. Matter stands dismissed, having been rendered infectious.
Right.
What a place.
See,
We have to mention.
Yes.
Not in this case, petitioner is presently serving in Assam Rifle matter. And in the last
CBC, who is there?
DPSC,
Mr. Deepak, you were there? You got instructions in the matter? I don't see.
last occasion, my lord, DPSJ was appeared.
The case is not entrusted to me myself. I will inform the.
Okay, last time Mr. R.K. Dev Chaudhary appeared. DSGA, item 3. DSGA, item 3. Wait for some time.
34.
May I please your Lordship?
Yes,
My lord, in this matter, my lord, instruction was sent in the month of month of August itself, my lord. And we also have prepared the affidavit, my lord. We was about to file, but because of the technical problem, we could not file, my lord. The technical problem is there, my lord.
ink
The-
was not there.
My impugn.
Ink was not there.
Yes, no, my lord.
Then,
Sorry, my lord. The impugn order was passed by the commissioner and he is the competent authority, my lord. But commissioner is not the party in the petition. Otherwise, without commissioner's affidavit, my lord.
no, Commissioner is the party, respondent
No,
one.
no, my lord.
Commissioner Secretary.
This is the commissioner and secretary, my lord. Commissioner and secretary, no post, he is from dispute commissioner and secretary, and it's a commissionerate, my lord. It's like director, my lord. So
There is no
commissioner,
secretary.
no, secretary is there in government, my lord. But it's the passed by the commissioner, it's a commissionerate, my lord.
It's okay. You see, these are issues which are very minor. You could have, on the day of appearance in 22, you could have told us that there is no secretary and we could have amended it.
Secretary is there, my lord.
Commissioner is also there.
Commissioner and secretary is the post, my lord.
It's okay, but
Yes.
after a year,
My
telling us that the post does not exist. That means for the entire year, nobody read the brief. Nobody
lord.
told us.
My
You
lord.
see, these are,
That part, it's
no,
our
no.
fault, my lord.
You could have filed an affidavit and then told us that the secretary is not there.
My lord.
And so therefore to accept the affidavit on behalf of the commissioner.
My lord.
But after a year, this
My
can't
lord,
be
we will-
happening.
Our affidavit is ready, my lord. Lordship may grant liberty to file on behalf of the other CEO and BDO, my lord. So that
No, do it.
commissioner-
You can file it on behalf of the commissioner and tell us that the secretary is not there.
Secretary is there, my lord. Commissioner and secretary post is not there.
That's okay, commissioner. I am saying commissioner is there and secretary is not there.
My lord.
So that means I am bifurcating it.
My lord.
So if it is on behalf of the commissioner, you file on behalf of the commissioner and tell us that it shall not be the affidavit of the secretary. And that ends the matter. But this is not a ground after a year to
My
take.
lord, lordship may grant 2 days time. We are filing, my lord. Or lordship may fix a date. In the meantime, they can file their reply also, my lord.
No, you first file it, then we'll give them time.
My lord,
Otherwise, this affidavits never come.
my lord, my lord.
And the officer in personal appearance is your name,
Myself Vivekananda Sanwal,
Yeah,
Assistant Development
designation?
Commissioner,
Assistant Development Commissioner, Panchayat Raj Development
Assistant Development
Commissioner.
Commissioner.
Yes.
Presence of the Assistant Development Commissioner was never required.
My lord, he is representing the commissioner, but commissioner post is not there, so he is representing the commissioner. my lord.
Okay. Mr. D. Mahanta, counsel for the petitioner. Says that standing counsel for the PNRD
My lord,
submits that the post of commissioner and secretary to the government of Assam is not there. It is submitted that the department is under a commissionerate and that the secretary is a separate post under the government of Assam.
yes, in the government, yes.
Full stop. Mr.
Sir, Vivekananda Shanwal.
Vivekanand, next para, Mr. Vivekanand Sonwal, the Assistant Development Commissioner, is present on behalf of the Commissioner to the Government of Assam PNRD Department. And it is submitted that only as the nomenclature of respondent of one was erroneous, the affidavit could not be filed. Next one.
May I correct one thing, my lord? He is the assistant development commissioner in the PNRD department, not government of Assam.
Achha, Development Commissioner in PNRD Department. But PNRD Department is not a government
My
organization.
lord, it's a directorate, my lord, it's a commissionerate.
No, but still it is a government of Assam functionary.
Government of Assam is a department, my lord, but it's a commissionerate, it's a part of the government of Assam.
Okay. Next one. Understanding also for the PNRD department, so that the affidavit in opposition is ready and these 2 days time to file it. So let the affidavit in opposition be filed. Within 2 days as prayed for. And the affidavit can be sworn on behalf of the Commissioner, PNRD Department. Next, the learned counsel for the petitioner shall take note of the submissions made by the learned counsel for the petitioner, standing counsel for the PNRD Department, and amend the cause title of this petition before the registrar within the judicial. Next, the personal appearance of the officer is dispensed with. Just after a week.
I love.
Or
You've got instructions?
Oh, sorry, for your listeners earlier direction, I obtained the instructions just now. সাইন করাই আছে as per
You see this, they are saying that you've been subjected to that medical. Yes.
The review medical, I am not on that matter. What had happened is this. I was found unfit. Initially, they had a suspicion that I was suffering from cardiomegaly, which means an enlargement of the heart. When I was sent to the for the proper tests on the next day, they gave a report of a tachycardia. Now, the uniform guidelines say that if it is tachycardia, I need to be hospitalized for that. Our judgments also, Honorable High Court judgment says, it is a situation where it may be transient in nature. So there's a hospitalization of 1 day and a specialist opinion is taken. Now, if you go by the report which I have announced, which was given to me, it would show that it is not a confirmatory test, number one. Number two, the doctors who were involved in the review medical board, one is a child specialist, one is a gynecologist, those types. And the hospitalization part was not there. All the petitioner that now is asking is, for the medical guidelines, they need to hospitalize me for days. Just find out whether it is transient in nature. If it is transient in nature, I get the job. If it is a permanent tachycardia, then I lose the job. There's no difficulty. Lordship, sir, kindly like to have one judgment for me, my lord. The situation why it is given,
2008 3GLT.
my lord, yes. That lordship will find. Many pages marked. There, the honorable court had held in this manner. The candidature of the petitioner number 5 was rejected, having found medically unfit on the ground of tachycardia, the pulse rate having been found to be 116 per minute. I am reading para 8, last few lines. Petitioners being villagers, is not unnatural that they present themselves before the medical officer, the BSF authority, to check their physical fitness. Their blood pressures may sometimes be recorded on a higher side, which candidature is rejected only on the ground as narrated above. Now, if lordship will kindly have their medical guidelines for a moment in the writ petition. Page 48. That is the simple issue. If they have done that, I would. Page 48, para 7E. For candidates who have been rejected on the ground of hypertension or tachycardia, should be admitted, hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in BP is of transient nature due to excitement, etc., or whether it is due to any organic disease. Now, if lordship will kindly have the medical
Then Mr. Goswami, you file an
certificate where I
affidavit.
was given.
You file an
Record to file
affidavit.
affidavit.
No, since you have said
Because
that,
they have details,
no, but apparently,
medical documents are enclosed in the
no, but
instructions.
apparently what,
It is required to be.
Page 42, if lordship will have for a moment, page 42.
this page 48, which Mr. Mazumdar has read, perhaps that has not been followed.
I will clarify, Malak, because I have some instruction.
You file an affidavit within a week, since you have the documents, we'll issue it after 10 days. After 10 days, give a date,
19.
1/9,
1/9 will be a difficulty. Can it be 2 days later?
3 lines. Because
8-9.
then it comes to 8/9.
Highly approachable.
The medical, they have just concluded the medical of the people, the merit lists are yet to be published. So that if lordship will keep in-
Merit list is not published.
No, my lord. For the merit list which was given, my lord, I was there. Otherwise, I would be there in the select list. And one more,
Mr. R. Mazumdar, counsel for the petitioner, as well as Mr. UK Goswami and CVC appearing for the respondents. Next para. The learned CGC has submitted that he has received instructions. Stop. We did not comment and praise for some time to file affidavit in opposition in the matter. Next para. The learned counsel for the petitioner has submitted that although the medical tests and other physical tests of the for appointment to the post of CAF,
constables in the CAPF.
the constables in the CAPF is concluded, but merit list is not yet published. Full stop. Next para. In view of if the affidavit in opposition be filed within, it will be filed within,
8.
so then make it filed within 7/9/2023, but there are 4 days vacation, 7/9/2023, list on 8 September 2023, next para. Taking note of the submission made by the learned counsel for the petitioner that the merit list has not yet been published, comma. The respondent authority shall keep a post of constable in the CAPFs. vacant till the next date of listing. Next para. The petitioner shall produce a certified copy of this order before the respond number 3 to bring the order to the notice of the said authority. Don't fill up one post then. Mr. Goswami, one post is not to be filled up.
In fact, the very report which they have depended upon says unconfirmed diagnosis. The very report which they depend upon says unconfirmed diagnosis. That is where the whole.
That high blood pressure is bad.
High blood pressure.
No, there's a high pulse rate is bad.
Tachycardia, they reject both tachycardia and bradycardia. They reject both high and low.
So I would be unfit then. Since my childhood, I have a pulse rate of more than 100.
Therefore, madam, when they tested for the these circumstances, they hospitalized. Therefore, because if it is usual for the man to have it, then it will not fall in that category of tachycardia.
But then it doesn't fall.
Then it doesn't fall. Therefore, madam, they hospitalize the person, take a reading for around 5 times a day to find out whether in usual circumstances that.
This gives me a reason to go and consult a doctor then. Because I have that tachycardia.
Yeah.
The normal pressure at any given point of time would be more than, sorry, the pulse would be more than 100. And if I take a walk, it's normal to have 120 to 25. By the time if I walk and go to my residence, it takes me 21 to 22 minutes to reach there, but my pulse would rise to 120 to 25, whatever. And it's normal for me since my childhood. I've been continuously monitoring it, but I have to go to a doctor now. Yes. I'll issue a notice in this matter.
Yes.
You've already been terminated. But Mr. N. Anik Singh, counsel for the petitioner, and Ms. R. Devi and CGC for the state. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition is served on the download CEC in course of the day. List after 4 weeks. I'll issue a notice in this matter. I'll issue a notice in this matter.
It's the third time, Lordship, I filed. Third time. Stay order,
It's okay. I can't.
stay order may be considered, Lordship. Without stay
But
order,
stay,
you
no, you are still not a service holder. We can't stay the matter. Somebody has been appointed.
corresponds with me.
You just, until the prayer is allowed and the appointment is quashed, we can't give you that post by an interim order. Mr. E.H. Alamgir, counsel for the petitioner, and Mr.
C.S. Hazarika.
C.S. Hazarika, then government advocate appearing for the respondents.
1, 2, 3, and 4, Your Lordship.
1, 2, 3, and 4.
5, Your Lordship, standing council, Panchayat will be there. Mr. S. Datta's name may be requested.
Mr. S. Datta, standing counsel for respondent number 5. Issue notice. Notice of motion returnable in 4 weeks. Requisite extra copies of the petition is served on the Honorable State and Departmental Council in course of the day. Next para. The petition shall take steps within 2 days for service of notice on the respondent number 6 by registered post to the AD.
Item 6.
The Honorable Council for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next para. The appointment of respondent number 6 to the post of as Anganwadi helper,
The worker, Lordship. Now he's promoted to what worker?
Worker.
Helper to
worker,
worker.
okay, Anganwadi worker would be subject to outcome of the
But she's
petition.
not in same area.
Huh?
Not in same area, it's my challenge.
Pardon me?
She is not in
This area, Lordship. Yes.
May not be, but I'm not staying it. Somebody must work. What happens if there is nobody? Then who will take care? You deposit 5 lakh rupees. You see, the children has to be taken care of. You deposit 5 lakh rupees, we'll give you a stay and then we'll appoint somebody else to that office who will take care of the children. Yeah. You can't be oblivious of what is happening in the field. Even one child, if it comes to Anganwadi center, has to be given that, has to be provided for. Correct?
7.
Yes.
May I please, your lordship, my lord, the case of the petitioner for appointment on compassionate ground has been recommended
2009.
by the DLC, the relevant portion at page 28.
No, but you see, you'll have to show us that the vacancy of that time is still available. The
Because,
SLC
my
has
lord,
rejected it.
Because that is not the ground of rejection of the case of the petitioner. If your
Yes,
lordship,
whatever,
there is
but
page
2000, you see,
page 28, actually,
the
there was a
different-
mistake on the part of the respondent. Page 28, relevant portion, my lord.
28.
Yes, my lord. Relevant
Because
portion.
Mr. Bora,
Yes, my lord.
everything said and done. The vacancy of 2009 would never be available. The number of compassionate appointment cases we are dealing with daily
Yes, my lord.
will not leave any post vacant.
My lord, yes, my lord, that instruction I have to obtain because and that instruction actually, my lord, government advocate can produce.
It just
Because
not be
as per the
available.
minutes, my lord, if your lordship peruses page 28, my lord,
Yes.
page 28, first paragraph. Serial number 3, Alok Dev, son of late so-and-so, ex-SI of police, expired on 16/5/2000, and late Swapna Dev, mother, ex-woman head constable, expired on 28/12/2009. Sri Alok Dev submitted application on 8/7/2010 and on 19/11/2013 respectively. The application of Sri Alok Dev received within 1 year from the date of his mother, as per statement submitted by the concerned office. As reported by the concerned dealing official that the proposal was submitted by number so-and-so dated 22/7/2010. But his name was not shown in the minutes of the meeting held on 23/7/2010. However, after threadbare discussion, it is decided to recommend the name of Sri Alok Dev for appointment on compassionate ground against any suitable vacant post subject to fulfillment of other criteria required as per the post applied for. So, my lord, when 2010 DLC, my lord, because it has not stated here, but unofficially, because it was the mistake on their part that his name has been dropped, my lord.
No, that's okay, but 2000, you see, you applied in 2009.
Yes,
You are approaching the court now.
no, my lord, because his candidature has been recommended by the minutes in the year 2019, my lord. The minutes dated, my lord, 9/7/2019. And thereafter, my lord, his case has been rejected by the DLC only on 21/12/2022, page 29, my lord.
Yes.
Your proposal was rejected by SLC in its meeting held on 10/2/2022 as per OM for the submission for late submission of your application. Now, my lord, regarding late submission, my lord, already DLC has held observed that he has submitted the application within time. And as per the office memorandum, if your lordship comes to page 17, my lord, that also stipulates that
Okay.
it has to be submitted within 1 year. Page 17,
Okay,
cross 3, my lord.
You are right.
Yes, my lord.
Mr. DP Bora, counsel for the
All our
petitioner,
base notices.
and Mr. TC Shriyal, and additional senior government advocate appearing for the respondents. Next one. The joint counsel for the petitioner is referred to NHR 8 of the petition, which is the minutes of DLC meeting held on 9/7/2019, wherein it has been recorded that the application of the petitioner for appointment on compassionate ground was received within 1 year from the date of death of his mother. However, the SLC has purportedly rejected the application of the petitioner for compassionate appointment on compassionate ground in its meeting held on 10/2/2022 on account of late submission of the application. Which is apparently contrary to the DLC minutes dated 9/7/2019. Next, accordingly, issue notice of motion returnable in 4 weeks, requisite extra copies of the petition be served on the government. Additional senior government advocate in course of the day. Next para. The pendency of the petition shall not be a bar for the SLC to re-examine the candidature of the petitioner in light of the hearing before referred DLC minutes. The next para, the petitioner shall produce a certified copy of this order before
SLC,
before
the SLC, my lord, chief secretary,
before the state level committee.
state level committee.
Okay.
Shared by the
He applied, my lord, twice, 10 and 2013. That's why something problem is there, my lord. So this time, my lord.
That's okay, but they have written it is within time.
That's why,
DLC.
my lord. And SLC minorities is not before your lordship.
You see, this the DLC had no intention to work because they say they are the first category authority to take a decision. They say we are recommending subject to other fulfillment, and who will decide those other fulfillments? Senior officers. As if just think of the situation where the DLC will write and the chief secretary will re-examine.
No, they can
And-
provide all these
That is
things.
your officer.
And in case of the petitioner, it was the fault on the part of the respondent that first DLC meeting held in the year 2010, his name has been dropped from the list. He was not considered, my lord. Although application was there, my lord.
Again on 19/11/2013, he submitted.
That's
That is a
okay.
representation.
No, that's okay. But once and first application is there,
Yes, my lord.
which is cognizance of which is taken by the DLC, they can't reject his case like that. That means nobody wants to work.
In-
Somebody has to read the file, they don't do it.
And
Because the DLC very conveniently writes, chief secretary will look into it. He is the best officer to read and write. It can't be helped. Let the chief secretary work hard.
that is.
Okay, next,
Obliged.
8.
Wait, please, your lordship.
Yes,
Petitioners for
issue a
lordship, there
notice,
the assistant engineers of PWD department.
issue a notice.
Lord, this matter can be disposed of,
No,
Milord,
no, I'm not disposing at the motion stage.
on the light of, Milord, the similar cases, Milord, other.
There
cases
may
have
be
been-
1001 cases, but I'm not disposing of in the motion stage without giving them notice.
My lordship,
Motion stage, I am not disposing of a writ petition.
my lordship.
They have a right to take their stand.
We had filed a representation, Milord, that is pending now, Milord, similar situation,
No,
Milord.
Representation,
Some writ
disposal, those
petitions
are
have
not.
already been disposed of.
my
I have
technical.
annexed the orders, Milord, in my petition,
Let them take a notice and then we'll, on the next date, we can do it,
my lordship,
but not today.
my lordship.
And Mr. M. K. Das, counsel for the petitioner, Mr. Enact standing counsel for the
Respond number 2,
Petitioner.
3 and 4.
respondent was 3 and 4, and
2, 3.
Mr.
I am for 1 year. CS Hazarika for respond number 1.
Yes, Hazarika, government advocate appearing for respondent number 1. Then you will be for 2, 3 and 4.
Yes, boss.
2, 3. Issue notice. A motion returnable in 4 weeks. Requisite extra copies of the petition be served on the London State and Department Council in course of the day. Next para. The pendency of the writ petition shall not be a bar for the respondent authorities to dispose of the representation of the petitioner dated
Okay, Milord, 10/5/2023.
10/5/2023. This after 4 weeks.
May I pray for a date, Milord?
Huh?
May I pray for a date?
Make a mention will, because I can't do it. There is enormous pendency.
My lordship,
You make a prayer, will, after if it's not listed, you make a mention, will permit you.
my lordship. Pray, pray.
9,
May I please, your lordship?
Yes, we are issuing notice.
But basically, this
Huh?
matter is, this is a covered case of.
I'm not disposing of matters in emotional
Hello.
stage,
Yes,
even if it is covered.
yes,
Mr. You say, yeah.
no,
Counsel
SD
for-
Roy.
Oh, Mr. SD Roy. I'm
Yes.
sorry. SD Roy, counsel for the petitioner. Who's for the respondents?
Respondent is for SDI, Your Lordship.
CGC.
Union of India, yes, sir, yes. Sir. And the staff selection commission.
Okay. Just give a no, not for CGC. CGC. Just wait for some time.
Yeah.
Nobody's there.
Yes.
Yes.
Earlier, Madam my lord, representation dated 21/6/2020.
21/6/23.
My lord.
Okay.
I'm sorry. Leave your word.
Ten.
You're there? You're there in item 9? Okay. We are issuing a notice. Mr. SD Roy, counsel for the petitioner, and Ms. S. Bawal and Ms. CC appearing for the respondents.
May I please, Lordship? Similar matter order has already passed. And. Oh, then, oh.
No, once you make a mention that it can be allowed, we'll dispose it out. Next one. The outset it may be submitted that another CEC, in her usual fairness has submitted that the writ petition filed by the petitioner is covered by previous decision of this court. And she has produced a copy of order dated 26/6/2023 passed by this court in WBC 3708 of 2023. Next one. In brief, the case of the petitioners is that they belong to OBC category and pursuant to advertisement dated 21/7/2018 by the Staff Selection Commission, they applied for recruitment as constable within bracket general duty in CAPFs, small s. Full stop. It is projected that they had come out successful in the recruitment tests. And were otherwise qualified under the unreserved category. Full stop. However, the candidature of the petitioners were rejected under the OBC category without considering their candidature under unreserved category. Hence, this writ petition under Article 226 of the Constitution of India. Next paragraph. In view of the hearing before referred order, dated 26/6/2023, passed in WBC 3708 of 2023. Order dated 31/3/2023, passed in WBC 2090 of 2021. And order dated 8/2/2023, passed in WBC 656 of 2023. This requisition stands disposed of at the motion stage with consent of both sides by directing the respondent authorities that subject to availability of vacancy, the respondents would issue order of appointment in favor of the petitioners, appointing them as constable within bracket general duty in any of the central armed police forces as expeditiously as possible, preferably within a period of 6 months from the date of receipt of a certified copy of the order. Full stop. Accordingly, the requisition stands disposed of at the motion stage without issuance of notice on the respondents.
May I please, Your Lordship?
I'll issue a notice.
About 1994, he was dismissed from service, and criminal case was, my lord, he is acquitted in 2010. And delay in latest, my lord, the petitioner is.
My lord, my revision of appeal as per there is.
No, he filed an appeal in a revision.
Yes,
That was also rejected, my lord.
no, that is pending. It's page 58, my lord.
This, he approached the Director General of Police on 16/11/2020.
2021,
He says that it is pending.
yes. So notice may go, my lord.
Hmm.
Otherwise, my lord, 1994 dismissed, my lord.
It's okay, but they should take a decision. Mr. P.K. Das, counsel for the petitioner, and Mr. T.C. Shudia, additional senior government advocate appearing for the respondents. Issue notice of motion return within 4 weeks. Requisite extra copies of the petition be served on the learned. Additional senior government advocate in course of the day. Next level. The tendency of this petition shall not be a bar for the
Director General of Police.
for the
That's number two.
Director General of Police within bracket, respondent number
Two.
2
Yes, sir.
to dispose of the resolution
That is
Representation,
my page 58, my lord, revision of appeal.
22,
22/9,
9.
2021, my lord.
58. Dispose of the representation of the petitioner dated 22/9/2021 within bracket annexure 11. Next one. The petitioner is at liberty to produce the certified copy of the order before the respondent number 2 to bring the order to the notice of the said authority. List out of Alex.
Obliged.
Will provide extra.
11,
I'm issuing a notice in this matters. This is this is PNRD matter
Yes.
that we'll be disposing of in the next date. These are matters which are otherwise covered.
Lordship,
By the
I'll,
district
I'll,
dispatch.
Mr. S. Doctor, he informed me that he's on legs in another court, Your Lordship.
Okay, but I'm just issuing a notice so that
Lordship, his name is.
on the next date we can dispose it off. Because these are covered matters. Heard Mr. R.M. Dekar, counsel for the petitioner. Mr. C. Hazarika Lane.
As Dr. Your Lordship, Standing Council Panchayat, he informed me that he's on list. His name is.
Achha. Mr. S. Datta, understanding person for the PNRD department, appearing for all the respondents. As per issue notice of motion, return over in 4 weeks, requisite instruct officer the reparation is served on the next departmental council in course of the day. Next para. The court takes notice of the submission made by Learned Counsel for the petitioner that the issue raised in this reparation is squarely covered by the previous decision of this courts, this court. Stop. Next para. Hence, an attempt will be made to dispose of the to hear this petition on the next return will date. This after 4 weeks. What are other matters?
Item number 12, 16, 23 and 24.
Just wait. Item
12, 16, 23 and 24.
okay.
I am obliged.
Again,
Issue notice and state.
my lord,
Mr. Chaudhary,
my lord,
you want your name to be recorded?
my lord, all that I was thinking, my lord, there is a subsequent development pursuant to that order. My lord, when the earlier direction was that they will be deemed to be under suspension. So therefore, my lord, they're entitled to subsistence allowance. When it was not paid, another round of litigation ensued. There, my lord, government has taken a stand that how can we pay subsistence allowance to contractual employee? Therefore, I think, my lord, if both these matters are taken together,
Let me, since I have issued a notice on the next date, you say we'll tag it. Otherwise, it happens, there's
Lordship
some.
will also fix it for interim orders on the next date, my lord.
uh,
The final disposal as your lordship.
Final, I'm going for final disposal,
Fine.
since the orders are
As
covered.
such, it is covered, my lord. Only thing is in the second round of litigation where government has taken that stand. Now that needs to be decided.
Okay.
Item number 17, my.
Segment 28 of the fixed
Mr. King Shah, senior counsel, assisted with Sahani. Okay.
Deep-
On the next date, we make a fair with.
Well, Deep-
11, 12, 15, 16, 23, 24, same. my lord.
Same.
Huh?
Same.
No, there
Now
are two
removing
other
of
matters
this
also.
glass has made it easier to communicate, my lord.
Yes, ma'am.
Otherwise, we have to put from that side.
But I have caused the state huge loss
Yeah.
because that was the necessity of that time.
Now it is not.
Now it is not. Um,
These are my lord. We call it in English language.
Necessary evil.
Different.
Can't help it. At that point of time, those were such worse times.
My lord, by
Again-
6:30, whole city would come to a standstill.
No, in
Does it
fact,
recollect that police used to
day
come up
before
with that
yesterday on
siren?
Saturday, day before yesterday on Saturday, we had a meeting on juvenile justice. I was chairing it. And one of the participants raised a very pertinent issue. He said that during this COVID period, all these street urchins were otherwise available in all markets. They had just vanished. So what was the social cause which made these street children vanish suddenly? Because some study has to be made. What is happening is
What
that
was the cause?
what is it? Something must have triggered. You see, today they are begging. On those days they were not found begging. So therefore, what is the social impact? What happened at that time? There was no study. So that could have given the government a handle to
And
take
the
care of those children.
Social welfare department of government should take
No,
up.
they conducted this meeting.
Right.
But
That's a very pertinent point, madam.
we all saw that, but never realized what is happening. So these are few things which maybe social engineering, they will take care of.
Right.
These things.
Diploma.
Okay. Make a prayer on that next date to get
Mal-
the fact. Item 13,
All right.
we are issuing a notice in your matter.
My lord, I pray for interim, my lord.
Yes,
Yes.
you are right. We'll give him an interim order. And Mr. Vijay Ghosh, counsel for the petitioner, and Mr. U. Hazarika, runner.
CS Hazarika.
TS Hazarika. I'm sorry, why I'm
One-
forgetting, I don't know. Counsel for the government advocate appearing for the respondent numbers
1, 2, and 4, your lordship.
1, 2, and 4. You should notice a motion returnable in 4 weeks. Requisite extra copies of the register is served on the Runner State and Departmental Council. In course of the day, next paragraph, petitioner shall take steps within 2 days for service of notice or respond number 3 by registered post with Devi, as well as by Dasti, by routing the process through the notice through the registry of this court and upon service. And affidavit of service shall be filed prior to the next date of testing. Next paragraph. The learned counsel for the petitioner has prayed for interim relief, which is opposed by the learned government advocate. Next paragraph. Considering the projection made in this writ petition that consequent to the order dated, judgment and order dated 2/6/2023, passed by this court in WPC 2204 of 2023, the petitioner was reinstated and reinstated by order dated 1/7/2023 and by the impugned show cause notice dated 9/8/2023 on the same set of allegations. The petition, the petition is sought to be proceeded with you are proceeded against this Assam, the discipline and service rules.
Yes, my lord.
Under the provisions of Assam service within bracket discipline and appeal, bracket close rules, 1964.
Lordship, in this, nothing is indicated here.
Nothing indicated here.
Lordship will perhaps not note that fact. Because it doesn't indicate that this is a rule 9 or any rule.
It
It's
is
just
not a notice at all. in
that-
the
Proceeded with, sought to be proceeded with.
It's not a notice in the IOC.
Stop. Next paragraph. As it prima facie appears that the petitioner is being proceeded with departmentally on the same set of charges which did not find merit in the earlier round of litigation, the court is inclined to stay the operation of the stay for the proceedings arising out of show cause notice bearing number capital A and B, 24/2023/5048 dated 9/8/2023. Issued by the Executive Officer, Amguri Municipal Board. Within bracket respondent number 4. Sir, the notice on 3 and 4. The 4 you will be appearing.
4 I'll be appearing, 3 your lordship notices.
Acha, okay. The notice on 3, within bracket respondent number 4. List after 4 weeks.
Deeply obliged. 14.
Is the same?
No, this is parameter. Item 14. His candidature was rejected because of his height was found 1 centimeter shorter than.
Okay, then you should notice then. Not a present call for the petitioner. However, Ms. Baba and CGC is present. You should notice a motion returnable in 4 weeks requisite extra copies of the red petition is served on the run at CEC within 2 days. Next after 2 weeks.
15.
No, please, your lordship. Lordship, this is a matter regarding termination from service. My lord. The principles of natural justice have been denied.
I'm issuing a notice. I'm not disposing of today. I will dispose it on the next date. Same as King's. Item number
15 and 16, 17. 15 and 16.
15, same like that. Mr. S. B. Laskar, counsel to the petitioner. Mr. S. Datta, CGC, sorry, standing counsel for the PNRD for all the respondents.
All the respects.
We'll try to dispose of the next day. We are
On
issuing a
judgment,
notice.
my lordship, it is covered by the.
I'm not disposing of at the motion
Yes,
stage.
yes.
I am aware of it.
Yes, yes,
One of such cases I have disposed of, but
Yes.
I am not disposing of in the motion stage.
yes.
15, 16, 17, same.
17 is little different.
Briefly, okay.
17 is little.
17, my lord. In this case, my lord, I have been placed under suspension, my lord, in terms of the order passed by your lordship, my lord. And this writ petition has.
Just wait, the file has gone.
My lord.
The file has gone. Since you made the submission, the file has gone. Just wait for some time.
18.
18. I'm issuing a notice. But I don't think ultimately you'll be entitled to any relief.
My lord.
I think
To the biometric issue.
it's okay, but I think I'm issuing a notice, but I think that you'll ultimately not be entitled to relief.
They are not, but my lord, there are crores of persons who don't have any Aadhaar card due to only this issue, only for
No,
this issue.
I'm issuing a notice. I'm not dismissing it, but this is what my impression is. That Mr. S. Chaudhary, counsel for the petitioner, and Mr. S. Datta, standing counsel for the PNRD, appearing for all the respondents.
1 to 3.
1, 2, and 3. If you notice, it is available in 4 weeks. Requisite extra copies of the red petition be served on the Government Department Council in course of the day. Petition shall take steps within 2 days for service of notice in the respondent number 4 by registered post for the AD. In addition, the petition shall also take steps, thus the on respondent number 4, by letting the process through the registry of the court and upon service and affidavit of service will be filed prior to the next step of this thing. Next one. The pendency of the petition shall not be a bar for the respondent authorities to re-engage the petitioner.
19.
You are there. One matter we are requiring your presence. Huh?
Item number 3. Yes.
Lordship, I am extremely sorry, sir. Item number 14, Lordship, I was in court number 2 lakhs, Lordship.
What happened in 14? I would not remember.
It was item number 14, Lordship, pass out, Lordship. I was in court number 2 lakhs, Lordship.
No, I never passed off any matter.
For it, Lordship, maybe day after tomorrow, Lordship, maybe listed, Lordship.
I passed an order. Just let me understand.
After 4 weeks, is. Non-ACS, Lordship. Just
Oh, so none of this. You want your name to be recorded.
name
Yes, sir.
that, Lordship, maybe listed next week or day after tomorrow, Lordship. Matter related to the appointment of the GD, Constable GD of the CRPF post.
I understand. I should notice. What else do you want?
Lordship, maybe next week, Lordship, maybe listed. This earlier similar order was passed by.
No, I'm not disposing of any matter at the motion stage. If that is your prayer, then I will be rejecting your interim prayer. Interim disposal at the motion stage, I am not doing it.
Okay, Lordship, maybe then my name may be recorded.
Okay, your name?
NH Lashkar Lordship.
NH Lashkar, item 14. Okay. Item 3.
Lordship, I'm very sorry, I was.
No, it's okay.
Lordship, instructions, Lordship, I have got. If I may particularly take your Lordship to paragraph 5 and 6 of the flag page.
You file an affidavit then.
I
You're saying
file
that it is a fake
Lordship.
receipt. You File an affidavit.
My lord, the withdrawal is fake, they say. The withdrawal of resignation is fake, probably.
He has
that
not
is what they
submitted any withdrawal, Lordship.
The specific instruction, that is where I.
Why? My lord, then
it
in
was-
that case, I have to
I will-
get that person to testify. The procedure is that the concerned
Whatever way, but
individual.
I'll issue notice and then since he has brought the instruction, specific instruction to that regard, he'll give you an opportunity of filing an affidavit.
My retirement date is coming on 1st of September. my
But that can't be helped. We can only make it subject to order of the court.
Yes.
lord.
Heard Mr. B. Pathak, counsel for the petitioner. Also heard Mr. Arkadev Chaudhary, Learned, DSGI appearing for the respondents. Next one. Pursuant to order dated 9/8/2023, passed by this court, the learned DSGI has produced a set of instructions which he has received along with forwarding letter dated 18/8/2023. In wherein it is projected that the annexure 9 to the petition contains a fake receipt. Right? Next one. The nature of issue raised in this writ petition, issue notice of motion returnable in. Will be retiring. So,
Lordship will keep it. First. If your Lordship will keep it by 30th, not 30th, Lordship. Yes, 30th, I'll try to find my
Right.
affidavit, Lordship.
Okay. Considering the submission made by learned counsel for the petitioner, that the petitioner would be superannuating on 31/8/2023,
31/9, man.
31/9.
Sorry, madam, 1/9.
No, he is
Oh,
going
1/9.
on, Lordship,
1st of September.
As
Okay.
per my instruction, Lordship, he is going on retiring pension. Uh,
No, it's okay, this is
First
submission
of September.
1/9/2023. Therefore, the learned DSJ shall make an endeavor to file affidavit within 3/08/2023. Next one, based on 3/08/2023. The instructions to which I have. Last time, date fixed on so before that.
Lordship, I take it.
Yes, yes. With the,
Otherwise, I thought he had a good case.
yes, that is what the impression was.
Hello.
But we don't know what will come out.
Lordship,
He has been actually put under a lot of duress by the CEO, my lord. Made to stand the whole day outside the campus, my lord. Just
No, it's
because he
quite
has filed his
possible.
writ petition.
It's quite possible.
anything
It's
is
quite possible. Yeah.
My lord.
19.
This case,
I'll issue a notice. Pendency will not be a bar.
that, and his another grievance is that he has already approached that, the director of medical education by submitting a representation.
So this way, it's not be a bar for them to dispose it out.
Or your lordship may direct the,
No, you see,
Yes, my lord.
I find it difficult to dispose of matters in the motion stage. Then the department comes out with so many things that this has happened, that has
Yes.
happened.
Yes.
Again, I interrogate the application, then restore it. Unnecessary,
yes,
it gives me trouble.
yes, my lord.
Twice or thrice it has happened.
Yes.
And then to restore it and then take up the matter, rehear it, undo the orders.
Yes, my lord.
is really bothersome at times. Mr. N.K. Kalita, counsel for the petitioner, and Mr. D.P. Bora, and standing counsel for the health department. You're appearing for all the
All
respondents,
the respondents, my
all
lord.
the respondents. Next paragraph. Issue notice of motion, return over the 4 weeks. Requisite extra copies of the representation is served on the Government Department Council in course of the day. Next paragraph. The pendency of the writ petition shall not be a bar for the Director of Medical Education within bracket Assam, within bracket respondent number 3, to dispose of the representation of the petitioner dated
My lord, that is
page, last page 40,
7/6/23, my lord, the last page.
dated 7/6/2023 within bracket annexure 8. Next paragraph. The petitioner is permitted to produce a certified copy of this order before the respondent number 3 to bring the order to the notice of the said authority.
Obliged, my lord.
Obliged.
You serve a certified copy, Mr. Kalita.
20.
I'll issue a notice. I think 50% disbursement has to be state.
Yes.
Lordship, interim.
50% disbursement can be state. You can only have a claim of 50%, not more than that. Mr. Nayak,
She was receiving maintenance.
She was.
no,
And,
no,
in
you
the
see,
pension book, Lordship, he is not the nominee.
no, but still as a wife, he gets the, you see, Mr. Nayak, the under the Mohammedan law, if she receives maintenance, then the property of the deceased is charged for that maintenance. That maintenance has to be paid. So the number second is that pension is not a property. That is the decision of this court. So otherwise also they will any property of the deceased will be charged with for that payment of maintenance. That is one part. Second part is that even if she is not a nominee, but the status of a wife is there, then there is a High Court judgment of ours which says that for Mohammedan they will be sharing the
One last judgment, Lordship, at this moment, Lordship, I will not be able to face for it. It will matter when the people dividend gets profit. And there it was held that ultimately it will be the statutory law that will prevail over the Lordship law. That is the law in the take.
Family law will not prevail.
Hmm?
Family law will not prevail. Statutory law will prevail. And it is a case of 45 years of maintenance since 1979.
because if that be so, then the proposition which I am saying will only follow that the property of your husband, only that can be charged for maintenance. No, then it not be,
Maintenance, except also section 125 maintenance. So maintenance, even of that Hindu Mohammedan law will not come. Section 125 will be irrespective of their religions. Section 125 will be applicable. It is not a maintenance under Mohammedan law.
you do whatever law research you want, but the ultimately law would be that it is only the property of that husband which would be charged.
We are
Pension
not-
is not a property.
We are not interested for maintenance anymore because it is already seized.
No, no,
Since
after
he-
that, after death, you have got no choice.
Lordship.
If the nominee is not there, you'll produce instructions we'll keep it after a week.
Department, government, personal department. ADC, ADC Musalpur. ADC Musalpur.
Department, ADC.
ADC.
Government will.
Personal department.
Deputy Commissioner, Musalpur law.
We issue notice or we,
Yes, notice may be issued Monday. Because private respondent is there, that have come.
okay, you are appearing for private respondent?
I am for respondent number 3.
Respondent number 6 is the private respondent.
I am for one.
Okay, accountant general,
four,
okay.
and five.
But Mr. D.K. Bhagwati, counsel for the petitioner, also heard Mr. T.C. Shodhia, learned additional senior government advocate appearing for respondent number 1,
1, 4 and 5.
1, 4 and 5.
And it took too long.
And Mr. P.K. and Mr. P. Nayak Leonard, standing counsel for finance department appearing for respondent number 2, and Mr. K.K. Mehdi, standing counsel for respondent number 3. Issue notice, including notice on the prayer for interim relief returnable in 4 weeks. Requisite extra copies of the reparation be served on the Learned State and Department Council in course of the day. Next one. The petitioner shall take steps for service of notice on respondent number 6 by registered post with AD. So the Learned Council for the petitioner would be at liberty to correct the postal receipt number and submit postal track report prior to the next date of listing. Next one. The prayer for interim relief would be considered on the next returnable date.
Let's say 50%, that may be.
No, because if we are not entitled to, then you will not get it. Even 50%, you may not get it. We'll consider it on the next date. I'm issuing a notice on the prayer for interim relief. This one's Wednesday. Give a date, the pension matters. After 4 weeks. Make it returnable on Wednesday.
25/9.
Well, probably earlier item number 4 was taken up, a similar issue had come up
Similar
during
issue.
recruitment, my lord, some disease of the heart was found, my lord. It's basically mild MR. Annexure 8 is, my lord, the medical report, which is impure. Annexure 8, page 29.
What is the disease you are having?
Mild
Same
MR.
tachycardia.
Tachycardia, mild MR.
Okay.
Color blindness.
What did you do in item 4?
Color blindness. Color blindness.
What did I do in item 4? What did I do in item 4?
Mr. Mazumdar, my lord.
No, what did I do? What is the order passed? I don't remember.
My lord, items for probably one post was kept vacant, my lord. And,
Okay.
our prayers ultimately would be that they should be considered afresh, my lord.
Page 8, Marco.
Okay.
In the middle, man.
Same order as in item 4. Mr. B, parted for the petitioner. Mr. A.K. Dattar of CEC appearing for the respondents. You want us to add that the respondents will be at liberty to conduct fresh
My
medical.
lord, my lord.
Then item 4 also add that. The pendency of the reparation shall not be a bar for the respondent authorities to subject the petitioner to fresh medical
Medical examination.
examination. Item 4 also get that added. Mr. Mazumdar's letter. Okay. I'm issuing a notice return in 4 weeks. Pendency shall not be a bar for. And to keep one post. What do you call? One post unfilled. That is the order we are passing.
Deeply obliged.
22.
I issue notice on the matter.
But before my lord issues a notice, it is my duty to point out the earlier order. The earlier round of litigation, we had to withdraw the writ petition.
It's
because
okay,
of-
we are issuing a notice. I've seen that. Or Mr. S. Das, counsel for the petitioner. And Mr. D. Upamanya, Learned, standing counsel for the health department, appearing for all the respondents.
1 and 2.
Only 2 respondents, 1 and 2.
There are private respondents, my lord.
3 to 7.
Issue notice of motion, returnable in 4 weeks. Requisite extra copies of the writ petition will be served on the Ghana Department of Council in course of the day. The respondent, issue notice. Petitions will take steps within 2 days for service of notice on private respondent numbers 3 to 7 by registered post with AD. The Learned Counsel, the petitioner is permitted to collect the postal receipt number from the registrant to submit postal track report prior to the next date of listing. Prayer for stay of salary that we are not.
No, 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 my lord. I'm not facing that, my lord. Only one indulgence. In the
Yes.
meantime, there are already 339 vacant posts. So, my lord, I only pray, my lord, one post may be kept as under
So
reservation.
that would be subsequent recruitment, not in this recruitment.
My lord, under this recruitment, I challenge this recruitment, the result which was published pursuant to
Okay,
this
then we'll make it
recruitment.
the
One post may
appointment,
be reserved, my lord.
the appointment of the selection and appointment of the private respondents would be subject to further outcome of this repetition.
Lordship, they already may have been appointed, Lordship, because
No, it's okay, but since he's challenging their appointment,
if not
if,
appointed,
no, even if they are appointed,
yes, Lordship.
then also he will be entitled to that, if somebody's
Yes.
appointment goes, then he becomes entitled to
Yes.
it.
Highly obliged.
Published, my lord.
17.
In this matter, my lord, at page 40, I was dismissed from service, my lord.
Yes,
This order I put to challenge in WPC number 104 of 2022 at page 41. And my lord,
okay,
this
here
order-
that Mr. Chaudhary said substantial allowance.
yes, my lord. Now,
That is
my
the
lord,
issue
my
here.
prayer is for payment of subsistence allowance and reinstatement, my lord. Since I'm in deemed suspension pursuant to order passed by this honorable court. And I impute
Okay.
the dismissal order has been interfered.
Mr. Ken Chaudhary, senior counsel, assistant to Mr. R. M. Decker, counsel for the petitioner, and Mr. S. Datta, learned standing counsel for the PNRD department. Next paragraph. If you notice, including notice on the prayer for interim relief, returnable in 4 weeks.
My lord, may I, the similar matter has been fixed on 28/8, my lord. 28/8. Similar matter, my lord. WBC number 4452 of 20.
2023. Revisit extra copies of the petition is served on the runner. And the department counsel in course of the day. List on Spencer.
My lord, I'm deeply obliged.
Obliged.
25.
Yeah, please, your lordship. This application, I have for the implement of the sole respondent, Deputy Commissioner Chief Secretary.
Mr. K. R. Bora, counsel for the petitioner, applicant, petitioners. Next, this interlocutory application has been filed for impleading Sri Aditya
It to become.
ADITYA, VIKRAM, Yadav, YADV, IS, Deputy Commissioner Sivsagar as respondent number. His respondent number,
One, sole respondent.
okay, as for substitution for you. Not implementing substitution of so respondent number 1. The present incumbent to the set post. That's all. Next one. This interlocutory application being filed on. It is filed in connection with the connected content case. This one. The prayer is allowed. The applicant is permitted to substitute the officer named herein before as substituted respondent number 1 in the connected content petition. In the content, you write, heard so. In your order passed today in the interlocutory IAC so and so. the registry shall substitute the respondent with the officer whose implementing is, whose substitution is allowed by the said interrogatory application. Next one, pending correction of the cost title, comma. Issue notice on the substituted respondent returnable in 4 weeks. Petitioner shall take steps within 2 days for service of notice on the respondent. Next para. The pendency of the petition shall not be barred for the substituted respondent to comply with the order of this court.
High level, sir.
26 for admission. 26.
May it please the lordship, can this matter be taken about after 2 weeks, lordship? Lordship,
So just let me go through it. This is an arbitration matter.
Please, your lordship.
Yes,
Kindly pass over the matter for the tablet. Mr. Gupta is in legs in court number 5 minutes.
just let him come because it's an arbitration matter. We have kept it pending for a long time.
lordship, they were supposed to file the objection today.
Let both sides come. I'm not hearing it piecemeal. Arbitration matters I am not inclined to adjourn
Lordship, I am,
the drop of the hat.
lordship, I am for the petitioner, lordship, it's a
But still, I'm not going to do it. Arbitration matters, I'm not keeping it pending.
lordship, the conducting counsel, which is AK
Then we dismiss it, but I'm not, not adjourning it. You may assist the court, you may not assist the court, but I'll not be adjourning it. Arbitration matters, I'm not adjourning at the drop of the hat.
He's suffering.
You want to assist, you do it. You don't want to assist, I'll read it. Correct. I'm not adjourning it.
28.
After some time, you get the CEC here.
28.
May I please your lordship?
Yes.
Lordship, the matter here pertains to selection of the petitioners for appointment, lordship. Lordship,
Just a moment.
This is very sulfur, the
But
surrender.
the scheme is no longer,
Yes.
no longer there.
lordship. Lordship,
Can you show that there is a scheme that is still being operated?
Lordship, on the last occasion, lordship, there was a instruction by the respondents, lordship, regarding payment of an amount. And there was a direction from this honorable court to put it on record by filing an affidavit, lordship.
We have filed 2 affidavits.
Lordship, regarding.
No, first of all, you tell us,
Lordship,
first of all, you tell us, has the petitioner not received any benefit?
no, lord. They have not received any benefit. Lordship. Lordship, my case is that their case has been processed, lordship, for appointment, lordship. And one of such communication is page 61, lordship.
61.
Lordship, pursuant to the direction of this honorable court in the earlier round of litigation. May I read, Lord? 61 is the type.
Just a moment.
Lordship.
But then we'll have to issue a direction to you to produce the record of having paid that benefit to them because she has denied receipt of money.
Lordship, now they have processed regarding payment of 1.5 lakh to each of them. That instruction was produced on the last date, Lordship.
Yes,
the rest.
22nd July 2023. That was the instructions, my lord. Lordship, kindly can see. petitioners may rehabilitate under they are, because they're for job, they are not, they are mid-50s now. Age is mid-50s. That's why, last instruction, July 22, 2023. Petitioners may be rehabilitated under the existing Swavalamban scheme of the government of Assam in rupees 1.5 lakhs is given as one-time grant to former militants.
No, but Mr. Sudhia, if they had surrendered pursuant to a scheme in 2000,
Yes.
at 2000 they were qualified for a government job, correct? But if you don't give them government job, if you don't also give them the assured payment, then the court can always invoke the public law remedy and give them compensation.
So, so this is the last instruction, considering of the foregoing, you are requested to kindly apprise the honorable court about necessary steps undertaken by government for rehabilitation of the petitioner. Now they are taking steps, sometime will be given, after 2 weeks. In the meantime, I will get it, necessary steps undertaken by the government for rehabilitation of the petitioners through available schemes, deemed as appropriate in the matter. So it is a 22nd July 2023, last month instruction. So let it be after 2 weeks. In the meantime, I will get it up to date instructions, whether what steps they have taken. Except under the schemes to rehabilitation, jobs, giving jobs is impossible. Swavalamban scheme is there. Necessary linkage with banks or available loans by the petitioners for economic activities under any scheme referred by concerned departments can be required as per Mr. laws. Let me have the up to the instruction after 2 weeks.
Ms. S.S. Hazarika, counsel for the petitioner. So she is referred to the order dated 24/7/2023, wherein it has been recorded that the government is ready and willing to extend one-time financial aid of rupees 1.50 lakh to each of the rate petitioners to start their own enterprise. Full stop. The Learned Mr. T.C. Sutyal, an additional senior committee advocate, raised for and is granted 2 weeks time to obtain updated instructions. Next para. It is provided that the dependency of this petition shall not be a bar for the respondent authorities to
release the
release
1.5.
the financial aid, the assured financial aid to the petitioners. Next para, list after 2 weeks.
Much obliged.
May I please, as a lordship?
Yes.
My lord, on the last occasion also, my lord, there was a prayer made on behalf of the Panchayat and Rural Development, my lord, for filing of an affidavit, my lord. My lord, what has happened in this case, my lord, a disciplinary proceeding had been initiated way back, my lord. That proceeding has not brought into its logical conclusion, my lord. My lord, they can brought this
When did
in-
it start?
My lord, the so-called, my lord, may be pleased to find at page 94, my lord.
No, what is the date?
Date is of, my lord,
When was the show cause notice issued?
yes, my lord, it is of
2014.
2014, my lord, correct.
Then we'll give them 2 weeks time. If they don't, then we'll quash it.
My lord, my lord. My
We'll
lord,
give
may
them
be
2
pleased
weeks
to-
time.
Yes, my lord. My lord, what has happened for this proceeding? My contemporary junior engineers is now assistant executive
get it.
engineer.
That's it to the SC PNRD.
PNRD.
SC PNRD. Just wait for some time. Just wait for some time.
My lord, my lord.
Are they?
Mr. Bhaiya, just tell me one thing. The, has the promotion process been kept in a seal cover procedure? No.
No, my lord, they have not even, my lord, revised my pay. They have not even, my lord, have not done anything, my lord, very pathetic, my lord. I have made all the prayers, my lord.
Okay.
Yes, my lord. All right.
This is item 30.
Lordship.
Yes.
Lordship, here, the grievance of the petitioner association is over fixation of age for retirement without correspondingly providing any retirement benefit to the members of the association. And that is in, and their submission is that it is in violation of the order passed by the Honorable Apex Court in Karnava Sharma's case, 2011-14 SEC 752. Lordship, therein not,
You have the copy of the suggestion.
yes, Lordship. I've got the,
You are only a Gaungura,
Gaungura, Lordship.
but there is a decision of this court which says that the Gaungura is not a civil post.
No, Lordship, the Honorable Apex Court says it's a civil post. There's service benefits needs to be. Paragraph 12 and 13 relevant. If I can amend.
But still we are bound with the division bench judgment of this court, where it is held that the upper age of retirement of 65 years
Lordship,
is in accordance with law.
Lordship.
Lordship, as such, we are not challenging that fixing of the age of, it's the prerogative of the employer, no doubt, that they can fix a retirement age, but without providing corresponding benefit in terms of a retirement benefit, they could not have done that. And that is in
No,
why,
no, once you see it's not covered by a pensionable service, then you can't make that service a pensionable service.
Lordship, no doubt we have been granted a fixed honorarium. What they say is that it's an honorarium, it's not just a token money awarded for some amount of service rendered. If your lordship peruses the entire service, the manner in which the service is being rendered, and if and the provisions in the fundamental rules with regard to grant of honorarium, and it will be seen from that they provision for grant of honorarium is that the service has to be undertaken with the permission of the government, and secondly, the entire time of the employee concerned, the person who is being given honorarium, has to be at the disposal of the government. And if those provisions, FR, etc., the other fundamental rules are taken into account, and even the provisions of the service rules,
You're drawing inference from which provision of the law?
Lordship, the fundamental rules, as well as the pension rules also. I'll be referring to pension rules also. That is a abrupt stoppage of the honorarium, which we are.
No, you see, it's not an abrupt stoppage. The Anganwadi workers, helpers, they're all in an honorary post. They don't get any pension.
No, Lordship, this is different because Honorable Apex Court also in the year 2014, the judgment which we have placed, that it is a civil post and the service conditions needs to be framed.
No, this is, you
They
see,
have taken only one aspect.
under the Assam laws, what is a civil post? What is the law in Assam? Which is the provision declaring a civil post?
Civil post.
What is a civil post according to the government of Assam?
Lord, civil force is the, my lord, the relation between the master and the servant lordships, as per the, my lord, that constitution. Constitution of, my lord, that ruled by, my lord, 3010.
310.
311, that
Yeah.
one cannot be dismissed without.
This is
But
the, my lord,
civil-
only relation between the, my lord, the master and the servant. My lord, this is the not the, my lord, equal to the, my lord, that regular service lordship. But I don't have the one judgment of the always judgment of the Supreme Court lordship. This is regarding, my lord, one Mozart case lordship. That is also Supreme Court says that there are full bench judgment. Three judges.
In that judgment, the Supreme Court has held it is a civil post.
Lordship.
But civil post, the
That
declaration
is
by,
not that, my lord, that as to the, my lord, that my lord, the permanent, my lord, the regular post of that, my lord.
it's not a,
Constitution.
Article 311. The lordship takes up the fundamental rules. I'll be referring to the relevant provision.
yes. You are going for a disposal of the matter,
Lordship,
then we'll take it up at the end of the day.
end of the
we'll-
day. Lordship, can it be taken up on tomorrow or Thursday, Lordship, any day? Tomorrow, or Thursday? I've,
No, since the matter is in the list, we'll take it up in the
end of the day,
end of the day.
Lordship. Yes, that will also be convenient, Lordship.
Hmm.
Yes,
Also,
yes.
one thing, maybe by the time she can also get an instruction. Page number 32, your lordship, if any turn. 32 of the petition. There's a certificate of the association also. This case has been filed in 2022. And this certificate appears to be valid till 2021 year also. Page number 32. Valid up to 19/9.
2021.
Excellent.
2021.
Okay, please.
Previous page is the fact written page of that of your lordship, page number 31 of your lordship. Valid up to 19/9/2021. And the second paragraph given under my hand at Guwahati on this 20th day of September.
This is Societies Registration Act.
My instruction is that we have applied for extension and it's pending, Lordship.
Yeah, right.
Lordship, we can place the relevant documents also.
Cooperative society, society registration. So. Do we have Assam society registration rules? Do we have such a rule? Then you have to produce it.
Lordship,
Then you have to produce that you applied for registration,
Lordship, we can produce the documents.
because this 2019 amendment, Assam amendment says, section 3D, effect of failure to renew registration, a society which fails to get its certificate of registration renewed in accordance with section 3C, its registration lapses and it shall cease to be a registered society. It has a consequence. Ms. D. Burgoyne and counsel for the petitioner. Also, Mr. J. Henry Clarence, standing counsel for the Revenue Department, appearing for respondent number
2 lordships.
2, and Mr. T.C. Hazarika, and
CS Hazarika for 1. CS
so C.S. Hazarika, and Mr. Government Advocate, appearing for respondent number 1, and Mr. P. Nayak, standing counsel for respondent number 3. Next one. The London Government Advocate, appearing for respondent number 1, has submitted that as per the certificate of registration of the petitioner society has lapsed. In this regard, it is noted that under section 3 capital D of the Societies Registration within bracket Assam Amendment bracket close Act 2019. Consequences of the effect of failure to renew registration causes the registration to lapse, and it shall cease to be, and accordingly the society shall cease to be a registered society within. Cease to be a registered society. Full stop. Next paragraph. In view of the said objection, the learned counsel for the petitioner. Grace is granted. How much time?
Lordship, a week's time.
A week's time to produce the document of renewal of registration. List after a week.
Lordship.
I'm returning back this judgment. We'll place it on the next date. I'll take a break and come back. Eight 2023.
Obligement. Item 32.
In this case, I have filed an affidavit, lordship, it is not on my record, lordship, let it be listed, lordship, along with the rest.
Just okay. It will have. It's a tactics video. It will be. When did you file it?
Lordship, on last Thursday, lordship.
Last Thursday, okay. Both sides are duly represented. It's another Upadhyay, standing counsel for the Irrigation Department has submitted that the the affidavit on behalf of respondents has been filed on Thursday, you said, 18/8/2023, first of the registration track and tag this said affidavit on record. List on 25/8.
Item 33.
My lord, here they had filed the counter, my lord, long back in 4th of June, my lord, but today we receive the copy. We'll file the, maybe give 2 weeks time to file the reply.
And Mr. R.P. Sharma, Senior Counsel, assisted by Ms.
Pooja Barua.
Barwa, counsel for the petitioner, submits that he has received a copy of affidavit in opposition filed by the respondents only today.
Yes.
And he waits for some time to obtain instructions and to file affidavit in reply if so advised. Just after
After 2 weeks.
2 weeks.
All right.
Mr.
K. Vishwakarma, my lord.
K. Vishwakarma, counsel for the respondents is present.
Item 36.
Yes, no representation from the petitioner. Justice, the matter stands adjourned today. List after 2 weeks.
Item 37.
The senior counsel is on pilgrimage to Makkah, Lordship. So kindly matter maybe pass over for a day.
Okay, the prayer made by the counsel for the petitioner, both sides are present. The counsel for the petitioner, matter stands adjourned today. List after 2 weeks. Yes, bill matter 38.
My senior is another good. I can't pass over time.
Yes,
Time-
file lordship. Search it, file lordship.
Charge sheet is fine.
Search it, file.
Then you have to send you back.
Subsequent matter lords. Already, two questions has been examined. One.
No, so it's a charge sheeted matter.
Search it.
The previous records are here. You can just go to it after some time. You check this record, the look of records are there.
Obliged.
We'll take it up at 2 o'clock then. Let her go through the records
Lordship.
at 2 o'clock. 39. Mr. Salia,
Please, your lordship. Lordship, this is like, condemnation arising out from the regulation.
your order has been complied with, no.
Alright,
Has the order of the court been complied with, no.
but, this is the amount.
You have received the money. Mr.
CMG con. CMG con.
Speak loudly, we'll have to write it.
Excuse me.
Tell your name loudly.
CMG con. CMG con. KIKON.
K-I-K-O-N.
KON. N.
learned counsel for the petitioner, upon instructions, has submitted that the petitioner has received the area salary for 1 month in terms of in compliance with the order of this court. Mr. Mr. A. Sharia, counsel for the respondent number 1 is present. Mr. On satisfaction, this contempt petition stands closed. Okay, closing it.
26.
Yes.
My lord, one of the issue involved in this petition, my lord, is pending before the Supreme Court. My lord, we have appointed
Supreme Court
the
has-
arbitrator from the railway,
Yes.
which has been challenged, my lord, subsequent to the decision. And I have received the instructions.
No, when it is in court, when it is applied before the court is not bound to provide arbitrator, which is the railway employee.
My lord, a similar matter, similar party, my lord. There is a stay, second paragraph. All the facts are there.
Similar matters are pending in the Supreme Court, Your Lordship. The main question was whether the railways can appoint their own person as an arbitrator or not, Your Lordship.
There were conflicting opinions, my lord, therefore the matter was referred to larger bench. And the larger bench order of the Supreme Court is also, my lord. What second paragraph of the other one?
Heard, Mr.
W. Sharma, Lord. W. Sharma, Lord.
Mr. Sharma, counsel for the petitioner, as well as Mr. H. Gupta and CEC for the respondents. Next paragraph. It has been pointed out at the bar that the issue relating to power of the railways to appoint a departmental officer as arbitrator is now pending consideration before the Supreme Court of India. Before a larger bench of the Supreme Court of India. You see constitution bench in terms of order dated. Well, 7/2023. Passed by the constitution bench of Supreme Court of India in the case of Central Organization for Railway Electrification versus Mrs. ECI, next word SPIC, next word SMO, next word MCML, within bracket JV, comma, CA numbers 9486-9487/2019. Stop. As per the said order, the SLPs are listed on 13/9/2023. Full stop. Next, accordingly, the matter stands adjourned sine die. Next, it is provided that after the decision of the Supreme Court of India in this regard, the party should apprise this court for
Lordship,
resumption of the present proceeding.
Lordship, I have challenged, I have a SL disorder also, Lordship, before the Supreme Court, your Lordship, by filing 3 SLPs, your Lordship.
Which is the which order?
Lordship, this arbitration petition 4 and 7 and 8, your Lordship, of this High Court, your Lordship. Keeping this
The
matter-
present proceedings you have challenged,
Yes, your Lordship.
this arbitration 4.
Yes, your Lordship.
It's okay. I did not mention that. Because I am saying that it's pending for the
Yes, sir.
constitution bench.
Yeah, but-
Okay.
29.
Lordship,
Yes.
Lordship, in item number 36, Lordship, I apologize, I was in legs in another court. Could my
What did I do? I don't know. Okay, you want to do it?
Lordship, we will be filing an affidavit, Lordship. They have filed an affidavit, we will be filing a reply, Lordship.
Answer the petitioner submit that we will be filing an affidavit in reply.
Reply.
How much time?
2 weeks.
In 2 weeks. The rest is adjourned today. We start for 2 weeks.
Much obliged.
Yes, Mr. Bhayan.
29.
Yes,
Lordship, I am appearing on behalf of Mr. S. Datta.
yes.
Lordship, the affidavit has been prepared and sent for vetting, ma'am.
Uh, I will be directing that the pendency shall not be a bar for the respondent authorities to consider a DPC to consider the promotion of the petitioner from the date his juniors were promoted. Mr. A. R. Bhuiyan, counsel for the petitioner. And Mr.
U. Sharma on behalf of Mr. S. Datta.
U. Sharma, appearing on behalf, counsel appearing on behalf of Mr. S. Datta, standing counsel for PNRD department. Next, the learned counsel for the PNRD department submits that the praise for how much time?
My lord, 2 weeks may be given.
If it is ready, why you need the 2 weeks time?
My lord, any reasonable time.
Well, he used to come to Dispur. In Chhat Puja, I see that people, they pay obeisance on the road. And within a day, they complete the ferry of, your officer is doing that only.
My
It will
lord.
take 2 weeks time
No, my lord.
to travel on
Any-
road.
any day. Maybe, my lord, 1 week time maybe.
No, I wanted to know because people may have certain, when they come to court, maybe they are taking their respects and giving respects to the court and then coming. Within a week.
My lord.
The place plan granted 1 week's time to file affidavit in opposition to the matter. Next paragraph. At this stage, the learned counsel for the petitioner has submitted that the show cause notice
My lord, it is at page.
was
6th of
issued to the
February
petitioner in the year 2014,
14,
5 to 2014, and the departmental proceeding has not been
completed.
completed. So it is submitted that the respondent authorities, without any reason, has not considered the candidature of the petitioner for promotion in the DPC, and therefore many of his junior officers, they have been promoted.
Promoted as assistant engineer, then to my lord,
assistant executive engineer,
promoted to the post of assistant engineer,
and then to
and
assistant.
then to the
executive-
post of
Assistant executive. engineer.
assistant executive engineer. So accordingly, it is submitted that the petitioner has become two rank
Mal.
junior, two rank lower to his juniors.
My lord, pay as per ROP has also not been fixed. my lord.
It is also submitted that the current pay of the petitioner has also not been fixed in terms of the
Revision of pay.
revision of pay rules. Next one. Well, next one. Pair of the learned council to the PNRD is allowed the affidavit in opposition shall be filed within a week from today. Next paragraph. The court takes a serious note of the submission made by the learned counsel for the petitioner that his candidature was not considered by the, considered by the DPC. And that he has been rendered to rank lower to his juniors. First off, ideally, the respondent authority should have adopted seal cover procedure for considering the considering his case for promotion by the DPC. First off. Till date, no reason has been assigned by the respondent authorities as to why the petitioner has not been given the benefit of revision of pay rules.
Right.
Next, but accordingly, the respondents are jointly and severally respondent numbers 1 to 6,
Mark.
sorry, 1 to 5.
1 to 5.
1 to 5 jointly and severally directed to consider the candidature of the petitioner for promotion by constituting a DPC. And the decision of the DPC shall be referable to the date on which the juniors of the juniors to the petitioner has been considered for promotion.
Right.
Stop. The pendency of the petition shall not be a bar for the respondent number,
1 to 5.
no. This will be no, respondent number 3
Yes, sir.
to take an appropriate, I, the director, PNRD, to take an appropriate decision. Give the benefit of revision of pay rules to the petitioner. In effect from the date when his juniors had been, when others have been given such benefit. Others in the rank of,
Assistant engineer, then in the post of assistant
from
executive. engineer.
the date is found entitled to. Next, part, the petitioner is permitted to produce a certified copy of this order before the director PNRD Assam, within bracket respond number 3, bring the order to the notice of the said authority.
But can a time limit be fixed for that?
I'm not saying that because we are taking up after a week.
Right.
I'm just, this is only to expedite the matters.
Yes. Obliged, my lord. Highly obliged.
Wait, please, your lord. Lordship, this I has been filed by the petitioner, your lordship. I
So this
may
is
be-
49,
49, sorry,
it's a bail matter.
sorry. my lord.
You've seen the records?
I've gone through the records, Lordship.
Hmm.
The last date of entry was 8/8/2023. It was fixed for production and appearance, Lordship. And Lordship, the result of arms was also there, Lordship. The bullet was from the arms that was recovered and found in the deceased body, Lordship. It was the same bullet, Lordship.
Same bullet.
Same bullet, Lordship, recovered from the arms. Gave a positive test. Lordship. I have flagged that. Oh, it is here. It.
Okay, in this case, my lord, I am entirely going to be able to inform him.
Uh, Something is wrong. So far as I remember,
Lordship,
in the petition that Caesar, that forensic, the pistol was sent for forensic.
Lordship,
There it says it's a USA made pistol.
Lordship,
Here it says it's a country made firearm.
Lordship.
So what was actually seized is not the
Prop-
examination. Have you checked that?
I have seen now,
No,
Lordship,
but where two pistols
views.
seized?
Two views.
No. Has two pistols been seized? No,
No, Lordship, one.
only one.
Then
What is the discrepancy? Please find out. Try to see the record.
Lordship.
That is what I remember.
Latest one I've seen.
No,
I will see both, Lordship.
because what I'm asking you is that
Two pistols or
one which is there in this petition.
Lordship,
I'll just flag it for you. That reflects that it is a US made pistol.
Lordship,
The report you are now submitting shows
Lordship,
it's a country made pistol.
Lordship.
Let's check this.
Lordship,
We'll take it after some time. Item 40. I flagged that.
The page 73 is the one of order of the DLC committee, which has rejected the application for forwarding it.
It's 2002 matter. Your
22.
no, 2002 your father died.
Yes.
My lord.
So we are now in 23 after
My lord, we take
after
page-
21 years.
my lord, we take page 73.
73.
Clause 4, my lord, this is the name of the applicant for compassionate appointment, people like a petitioner, my lord. My lord, the date of application, the authorities have mentioned my lord, two dates. That is 21/5/2002 and 28/2019. My lord, admittedly,
Mr.
my lord,
Gupta, admittedly, this ground has some reasons. Your father died in 2002.
my lord,
In 2002, the vacancy of that year can only be considered.
it was not considered. This is my case.
No.
My
Is it your
application-
case that 2002 vacancy is still available in
No, my
BTC?
lord, my application was not even taken up by the authorities.
No, that's okay, but tell
And by
us,
this
today
letter-
we are asking you,
Well-
is a vacancy of 2002 available today? It can't be. It will be a fruitless exercise. You see, the High Court order must carry some meaning. If I ask the authorities to find out whether 2002 vacancy is there, with the amount of compassionate cases we are taking up daily, I don't think there is any chance that any 5% vacancy of year referable to 2002 would be available. If you can show us that the vacancy still exists, we'll allow the reparation right here.
Well, my contention is that, my lord, the authorities ought to have, my lord, because in terms of the Achyut Ranjan Das, my lord, there is a specific time frame in which the applications have to be carried forward by the authorities.
They have it, my lord,
But
not
two
carried
thousand
it
two,
forward.
2002, you are coming in 2023.
No, my lord, I have, my lord, given detailed list, my lord. It was under consideration, my lord, yeah, because
No.
the very fact. of-
21 years, if you can, you can sustain yourself, whatever condition be it, you'll not be entitled to constitutional appointment. The urgency is not there.
No, but the authorities have considered my application, page 73, which I have read. They have considered the application today, my lord. They are
Correct.
admitting the fact that my application
But
was
the
kept.
5% quota is not available, they said, not recommended due to non-fulfillment of criteria of 5%
My
reserve
lord,
quota.
in clause 15, my lord, clause 15 of the, my lord, page 29, the office memorandum. My lord, the 5% has to be, my lord, if my lord will take page 91. Page 91, which is the office memorandum governing.
You see,
the-
but has the law changed? The requirement to consider is of the vacancy, what you call the vacancies which are there in the year of the death of the father. Has that been changed? Is that altered that 2002 instead of 2002, you will be now considered for 2023 vacancies?
But since my application was kept pending by the authorities,
It will not be granted. You will be dismissing your petition.
my lord, they
If
have not.
5% quota is not there, it is not there.
Well, they are considering my application now and rejecting it on the ground of 5%. Therefore, my lord, it will be governed by the present office memorandum. Because the authorities have considered my application now, my lord, the page 73.
It will be,
in order.
just tell me, Mr. Gupta,
Page
it will be
90.
referable to which year? Vacancies will be referable to which year? It can't be present vacancy.
But the DLC is sitting, my lord, only in the year 2000, my lord, 21. The DLC sat, my lord, only in the year 21, considering my application. It is very, my lord will take page 91. Clause 15 of the office memorandum, my lord, if sufficient vacancies are not available in a particular office to accommodate the persons in the waiting list for compassionate appointment, it is open for the administrative department to take up the matter with other departments and offices to provide at an early appointment on compassionate grounds to those in the waiting list. So, my lord, the rejection is on the ground that 5% vacancy in a particular department is not there. Whereas, my lord, the office memorandum dated 1 June 15 provides that, my lord, it should be taken, the other departments also should be taken into consideration for calculating the 5% vacancy.
But you see, this meeting of the DLC
No, lord.
of interested department is at page 24 onwards,
No, lord.
correct?
It's,
So except for one which is from the High Court order, there's no recommendation. You just show us that 5% vacancy is available in any department under the BTC for compassionate appointment referable to that year.
any other,
Yes,
my lord.
you show us because this is an exercise which is in futility.
My lord, it is for the authority, that is what my prayer is, my lord, to consider in terms of the clause 15 of the OM. If the authorities reconsidered my prayer,
You see, this issue of sending the matters to the department by saying that you dispose of the representation, do this, do that, it doesn't help. It creates a multiplicity of litigation. I'm asking you a question, 2002 vacancy, whether it is there in any department. Because 2002 vacancies will never be there.
that is what our grievance is, my lord. I have in my
No,
petition.
then you approach the civil court, get a suit for compensation and get compensation for not being, for your application not being considered in due time. But compassionate appointment will not get.
But my humble submission would be, my lord, if the authorities are considering my
No,
application,
no, we're
in the
discussing
year
it. I'll
2000
give my reasons, but I'll be dismissing it. This is something which is not permissible.
well, they have considered my application in the year 2021.
Correct, I'll
They
give my
also
reasons.
have rejected my application saying that it's a 2002
I'll give my
application.
reasons, but 2002 vacancies to consider it right at this stage in 2021 would be, is not in consonance with Achut Shankar. Your delay
They
itself
have
is a ground.
Well, I have explained the delay, my lord, because I have been in constant touch with the authorities, my lord.
No, that's okay. It doesn't extend the period of limitation. I'm rejecting it. I'll be dismissing and give my reasons. Mr. H. Gupta, counsel for the petitioner, and Mr. S. Bora, standing counsel for the BTC, appearing for respondent numbers.
But I got 5 and 6.
No, you'll also be appearing for 2, 3, sorry, 3,
Not
3, 4, 5, and 6.
3, 4, 5, and 6. What's it?
3, 4, 5, and 6. And the irrigation is Mr. N. Upadhyay, Learned Standing Counsel for Irrigation Department, appearing for respondent number 1 and 2. Next slide. By filing this petition under Article 226 of the Constitution of India, the case projected by the petitioner is that his father, late Bhagavan Bhagadhan Chandra Dekar, who at the relevant time was working as mechanic within bracket grade 1 in Kokrajhar Mechanical Division within bracket irrigation. Kokrajhar had died in harness while in service on 1/4/2002. The petitioner applied for compassionate appointment on compassionate ground on 21/5/2002. It is projected that the said application was duly forwarded by the concerned authorities on 21/5/2002. The case of the petitioner is that the respondent authorities, including the DLC, did not take timely decision on the application filed by the petitioner. The learned counsel for the petitioner has referred to the communication dated 29/1/2011 by the executive engineer for Kokrajhar Mechanical Division within bracket irrigation. The what is CHD irrigation? CHD means the capital CHD irrigation, BTC, and superintending engineer, Kokrajhar Circle irrigation, thereby submitting a list of candidates who have applied for appointment on compassionate ground. Despite the said communication, the respondent authorities did not take a timely decision on the candidature of the petitioner. However, the petitioner was informed that by a communication dated 28/9/2019, the proposal of the petitioner was returned back with a request to the executive engineer, Kokrajhar Division within bracket irrigation, to submit the same to the DLC for taking necessary action. The petitioner is also referred to a communication dated 19/7/2021 by the Deputy Chief Engineer Irrigation, Assam, that all the BDOs under the irrigation department were to take necessary action for finalizing all pending compassionate ground appointments. Case prior to 2017 within 3 months. Full stop. Which was so accordingly, the executive engineer, Kokrajhar Mechanical Division, Irrigation, had once again enclosed the proposal for appointment of petitioner on compassionate ground by forwarding letter dated 10/9/2021. Followed by another communication dated 16/10/2021 to the Council Head of Department, Irrigation, Kokrajhar. Thereafter, the thereafter meeting of Committee on Compassionate Ground under the entrusted department BTC was held in the conference hall of was held on 1/11/2021, and the candidature of the petitioner was rejected. No, was not recommended due to was not recommended, inverted commas, not recommended due to non-dash fulfillment of criteria of 5% reserved quota, inverted comma post. Next one. The learned counsel for the petitioner has submitted that on the date when the proposal of the petitioner was considered by the Committee for Compassionate Appointment, BTC, policy of the Government of Assam on compassionate appointment as per OM dated 1/6/2015 was prevailing, which required under clause 15 thereof that if sufficient vacancies were not available in any particular office to accommodate the candidates, it would be open to the administrative department to take up matters with other departments of the government and provide to provide early appointment on compassionate ground for those in the waiting list. Accordingly, it is submitted that the respondent authorities had only considered the candidature of the petitioner under the Kokrajhar Mechanical Division within bracket Irrigation, Kokrajhar, and not the other departments. Accordingly, it is submitted that it was the respondent authorities who had delayed consideration of the candidature of the petitioner, which is violative of the judgment of this court in the case of Achyut Ranjan Das versus State of Assam and others. With the citation, which provides that timely consideration of the application should be made. Next para. with regard to the materials available in the writ petition. It is a fact that as per pleadings made in the writ petition, the petitioner, the father of the petitioner had died on 1/4/2002, and the petitioner had applied for appointment on compassionate ground on 21/5/2002. To stop, therefore, the petitioner had submitted his application on time, and no delay could be attributed to him. Next paragraph. However, under the prevailing OM dated 1/6/2015, compassionate appointments are required to be made only to grade 3 and 4 posts against the vacancies under the direct recruit quota. In the present case in hand, the candidature of the petitioner was rejected on the ground that not recommended due to fulfillment of criteria of 5% reserve post. Full stop. But Mr. Vora, there's one point which you'll have to clarify. Although I'm saying that the petitioners will have to show it, but I don't find the petitioner would be sufficiently equipped to know if there are vacancies in any other department. So ultimately, you'll have to take a decision.
That is so. At the same time, but the application may remains in force for only for 2 years, madam. That page number 90, principal number 3.
No, but you have taken up his case after
Yeah, we have taken up
20
that.
21 years
Lots.
at your own motion. Once having taken that, then it would not be permissible for you to not comply with this OM,
Definitely not, sir.
because that would be giving premium to your own inaction, number one. And it will encourage violation of the of this OM. I think you have to take a fresh decision on the candidates of the
Sir,
petitioner.
it can be done, madam.
You'll have to take up
Because
because
there's clause 15, it says,
you have
not
to do
only-
it. The exercise, whether you like or not, you have to do it.
that's a fact.
You will send the matter again.
Monday.
Next matter. It is noted that as already referred to hearing before, the petitioner is not accounted, is not to be blamed for the delay, which had occurred on part of the respondent authorities to take up the matter of the petitioner in DLC. In the committee for compassionate appointment of the, you call it BTC or BTR?
BTC, madam.
Of the BTC. Full stop. It also appears that the respondent authorities have blatantly violated the conditions contained in the OM dated 1/6/2015. As well as the judgment of this court in Achyut Ranjan Das within bracket Sutra, which provides that the district level committees would meet every 2 months on the last Saturday of the second month as per principle 4. That's true. The respondent authorities have also violated the provisions of clause 15 of the OM. Which requires the administrative department to take up the matter with other departments to provide an early appointment on compassionate grounds for those in the waiting list. Admittedly, the candidature of the petitioner was not rejected. So therefore, the petitioner is deemed to be in the waiting list as his candidature was ultimately considered in the meeting of the Committee for Compassionate Appointment of BTC on 1/11/2021. Next level. The petitioner is not expected to interfere in the decision-making process of the Committee for Compassionate Appointment of DCR. And therefore, it was the duty of the said committee to find out if there was any vacancies where the petitioner could have been appointed. Full stop. Next, therefore, the court is of the considered opinion that this is a fit an appropriate case for setting aside. Where is that list?
Page 73.
73. Set aside the minutes of meeting of the Committee on Compassionate Ground under interested department of BTC held on 1/11/2021. Insofar as the rejection of the candidature of the petitioner, namely Sri Vipul Deka, son of late Bhagavan Chandra Deka, is concerned. First of all, the Principal Secretary BTC is directed to pick up the case of the petitioner for appointment on compassionate ground and reconsider the same in terms of clause 15 of the
15.
15 of the OM dated 16 OM number ABP full stop 50/2006 of the part PT of the 182 dated 16/2015. Okay, 14 and 15. 14 and 15 of the Sudan Constitution. And other provisions of the said one. Next one. The petitioner shall produce a certified copy of this order before the before whom?
Because of the Principal Secretary.
Before the secretary.
Principal Secretary.
Principal Secretary, Borderline Territorial Council. So it is provided that on receipt of the said, on receipt of certificate copy of this order, the secretary, BTC shall reconstitute the committee for compassionate appointment.
We'll take up in the next DLC.
No, they will take it after 10 years then. You have taken up after 21 years. Now they will again shift it, reconstitute the committee was also within a period of, within an outer period of 2 months from the date of receipt of a certified copy of the order. And to take up the candidature of the petitioner in terms of the said one, specifically clause 15 thereof. Needless to say that any decision taken by the said committee shall be communicated to the petitioner. Is the email address to be provided to by the petitioner.
That's a 439 application, my lord. Your lordship had earlier rejected it. And that order your lordship will find at page, my lord, 37 onwards. 37, my lord. Annex
Yes.
6, 37 onwards, my lord.
Yes. Oh, so that
Yes, my lord.
driver poisoning.
Yes, my lord.
Yes.
My lord, from this order, it appears, my lord, had lordship had directed to have a speedy trial, my lord. In the charge sheet, there are 11 witnesses. And before your lordship passed this order, before that, my lord, 2 witnesses, my lord, had gone, my lord. Till date, no more, my lord. And the last date was on Saturday, last Saturday. There is on 19th August, my lord. Last date was on 19th August, my lord. No witness turned up, my lord. And so far, my lord, the petitioner is concerned, my lord, they are behind the bar for 463 days as on date, my lord.
463.
Yes, my lord, 463 days, my lord.
When he was arrested?
He was arrested, my lord, on 14/5/2022. And the other one arrested on 17/5/2020.
14/5/22 is number one.
Number one and number two is 17/05/2022. And while this case was pending, my lord, both the petitioners were arrested in another case. That is, my lord, they were shown arrested, my lord. And in that case, my lord, I approached this court, my lord, and I have obtained, my lord, bail, my lord, that your lordship will find at page 42, my lord. DA number 202923. And in that case, my lord, while granting the bail, my lord, this honorable court, my lord, was pleased, my lord, to allow the petitioner to go on bail, my lord, with a surety from Morigaon district itself, my lord. That your lordship will find at page 44, last paragraph. And my another submission is that, my lord, page 31, the part of the charge sheet, my lord.
Just a moment.
Right.
Okay.
Or page 31 for a once, my lord, the part of the
31.
charge sheet, my lord. The lordship will receive the brief facts of the case, my lord. Well, as the last two line, my lord, the lordship will see, my lord. Well, they used food poison, my lord. The summary of the case is that on so and so, complainant so and so, or village so and so, stating that on 21/3/22, complainant coming from Guwahati towards Nagaon by a private alto car, then the driver and another accused person stolen away rupees so and so, mobile, laptop, and of the complainant by used food poisoning, food poison, my lord. The accused person fell down, the complainant at the PO and attempt to murder, my lord. So now the lordship comes below, my lord, from below, my lord, sixth line, my lord.
Yes.
My lord, they have collected the medical report of the complainant come victim, my lord.
Yes.
Now, while going through the record, my lord, I think it was a flag mark, my learned friend. Nothing is found there, my lord.
About poison, there's nothing. Inspection not done, I think so. Lord.
Next week. Next week. September.
Okay. Yes,
Well, considering the length of detention and the stage, my lord, of the trial, my lord. 11 witnesses, my lord, till date only. two,
no,
my
but
lord.
how to come out of this Satyendra Kumar until?
Yes, that's true, my lord. My lord, and moreover, my lord, in the 302 case, my lord, I got bail, my lord. My lord, the stage of the trial, my lord, out of 11, only 2, my lord, has been examined, my lord.
Yes, but Ms. Begum,
His attitude is very bad, Lordship.
no, you see, there's a defect in
Offender-
this. What Mr. Datta is pointing out, there's a defect in investigation.
That is Lordship, FSL is not clear that about poison is not there, Lordship.
You see, the victim was not subjected to toxicological test.
That is. I'm really. So the lot, later doctor also be examined, Lordship.
But nothing will come out. If some victim is administered poison
Lordship.
and you don't subject him to toxicological test, what would happen in the trial?
That is, that it is. But they are habitual offender, Lordship.
No, that is okay,
That is,
but we are not punishing them. The requirement is that they must face trial. If he is ready and willing to face trial.
Moreover, a local surety of Morigaon district itself. So lordship allows, my lord, a local surety of Morigaon district itself. Because I belong from Borpeta, my lord.
Because you see, we all know about the guarantees people give. What is that? What is that? It came into national news. For one airlines, few guarantees were given by farmers at Haryana. Remember? For a loan taken by the airlines. Villages at Haryana had given
My lord.
their guarantee. And when the police caught them, they said that they never went to the bank. And the gentleman who took the loan is now in UK for that airlines. But then we'll release him then on bail.
condition may be.
Hmm?
Condition may be imposed, Lordship.
Heard Mr. N.J. Datta Rangan, counsel for the petitioner. And Ms. A. Begum Rangan, APP for the state. Next, para. The previous application for bail of the petitioner was rejected by this court by order dated 12/6/2023. Passed in BA 1557 of 2023. To stop. The learned counsel for the petitioner has submitted that in the said order, it is reflected that only 2 out of 11 witnesses had been examined as on 25/2023. To stop. On instructions, he has submitted that the last date of the case was fixed on 19/8/2022, but no witness had turned up, and therefore, as on 19/8/2022, the status of the trial of Sessions case number 195 of 2022 was that only 2 out of 11 witnesses had been examined. Next, the learned counsel for the petitioner has submitted that the petitioner number 1 was arrested on 14/5/2022 and therefore is in custody for last 463 days. And the petitioner number 2 was arrested on 17/5/2022 and therefore is in custody for last 460 days. That's true. Next one. Learned counsel for the petitioner has also submitted that in a similar offense where the petitioner was charged under section 328, 392, 302, 34 IPC, which was registered as Jagiroad PS case number 192 of 2022 and tried as Sessions case number 194 of 2022. The petitioner was granted bail by order of this court dated 26/7/2023, passed in BA 2029 of 2023. Next, it is also submitted that in the scan copy of the case records, it can be seen that the alleged victim was purportedly poisoned by the petitioner, was not examined for, was not subjected to toxicology tests to find out whether any poison was administered on the victim. Next part. The learned AVP has opposed the prayer for bail on the ground that the petitioner is a habitual offender of drugging passengers in his vehicle.
Yes.
And thereafter looting them. So it is submitted that in the present case, the petitioner was drugged and his belongings were stolen. And that when the people found him, he was taken to Jagiroad Civil Hospital and thereafter to Guwahati Medical College and Hospital. No, not in this case. In this case, what happened? The victim was drugged while traveling from Guwahati to Nagaon in the private auto car being driven by the petitioner. And he was drugged in a tea shop. And that while crossing Nazira Ghat, NAZIRAGHT toll gate, the victim became senseless. And when he regained sense, he found that his belongings, including mobile phone, charger, cash rupees 20,000, laptop, watch, key of his personal car, files, clothes, etc. were all looted. He was admitted in Guwahati Medical College and Hospital and was undergone treatment for 3 days. It's something that in a similar case, which has been tried as sessions case number 194 of 2022. The petitioner had drugged the victim who was traveling in his vehicle. And his belongings were looted and thereafter the victim died. Hence it is noted that the petitioner is a habitual offender. And therefore, ought not to be released on bail. Next slide. Next, having noted that the petitioner has secured bail in connection with sessions case number 194 of 2022, where charges have been framed against the petitioner under Jagrut case number 192 of 2022, being tried as sessions case number 194 of 2022.
Yes, ma'am.
Under section 328, 392, 302, 34 IPC. Is lesser offense than one by which the under which the petitioner is charged in the present case. And having noted that till 19/8/2022, the two witnesses have been examined by the prosecution out of 11 witnesses. Court is inclined to release the petitioner, namely so and so on bail, on his furnishing a bail bond of rupees 1.50 lakh with two suitable sureties of like amount to the satisfaction of the learned sessions judge Morigaon. Well, it is provided that while accepting the sureties, it would be permissible for the learned session judge Morigaon to impose appropriate conditions. For accepting such very bond. Okay, good. Yes. It may be, the next one, it may be mentioned that this court audited 12/6/2023 in BA 1557 of 2023 had requested the learned sessions judge Morigaon to examine if it would be appropriate to issue directions to the prosecution to produce the remaining witnesses in a time-bound manner and to take up the trial of this case by giving short dates and not to take up the case on day-to-day basis. If the board of the court so permits. Full stop. Nonetheless, witnesses have been examined between 12/6/2023 and 19/8/2022. It will have a growth in it. Next one. Subject to any other conditions that will be imposed by the learned sessions court while accepting the bail bond, comma. The bail is granted by the court on the following conditions. Here are the conditions. Next one. Along with the bail bond, the petitioners shall submit separate individual undertakings that they would attend the court on each and every date fixed for trial. And in the event they are unable to appear on any particular date, comma, they would ensure that they are duly represented by their learned counsel, duly authorized to cross-examine the witnesses and whose evidence is recorded in their presence. Whose examination in chief is recorded in the absence of the petitioners. The petitioners shall not give the jurisdiction of the state of Assam without prior written permission from the learned sessions judge without Morigaon. In the event the petitioner leaves the territorial jurisdiction of the state of Assam without prior permission of the learned sessions court, it will be open to the learned session judge, Morigaon to cancel bail and to take petitioner into custody till the completion of trial. Next, in the event the petitioner is found to be involved in any similar offense, it will be open to the, and the same is brought to the notice of the learned sessions judge Morigaon. It will be open to the learned sessions judge Morigaon to cancel the bail of the petitioner and to take him in custody for the remaining period of trial. Applications stands allowed. The records of BA. There are 3 accused persons. 2.
Safikul Islam
The applications
and
of
Janaul Haq. I'm obliged, deeply obliged.
49.
Lordship, my senior AK Sharma is suffering from eye flu, your lordship. So kindly please pass over the matter for a week.
No. Maybe have to adjourn it. Prayer for adjournment is made on behalf of the Government Council for the petition on the ground that the council holding the brief is suffering from high flu. So Ms. A. Begum, Learned APP, and Mr. Mr. Fakrul,
FKR.
then council for the informant is present. List after a week.
Much of that.
Date is long.
Sorry, I'll give a date. Give a date after a week. Give a date.
Lordship, 8/9.
8/9.
If you want. So I for getting the order, my lord, in case 23,
For correction of order.
correction of order,
Yes, page
case 23.
23. Oh, you are saying that it should be industrial tribunal or labor court, whatever.
In case of
You'll allow it.
Labor code Dibrugarh.
Huh?
Labor code Dibrugarh.
Wherever I'm, now I'll not say whatever.
my lord,
Section 11, whatever is provided in section 11,
my lord.
so that even if it is not this code, any other code. Okay. Mr. Anne Berman, I'm counsel for the applicant. Also heard. Mr. K. Khalifa, counsel for opposite party number
5, Lordship, 5 and 6.
5
5
and 6. And Ms. R. Decker, advocate appearing for opposite party number 7. For the state, you are there.
Lordship, yes, in the original case, we were our name was not somewhere else. Yes, this one number 1, 2, and 4.
Opposite party number 1, 2, and 4 is a case, Hazarika, government advocate.
First, my friend.
You're for?
Respondent, they are earlier appeared respondent 2 and 3, Lordship.
Mr. A. Ali. Your name? BP Sharma for respondent number, opposite party number? 3. Okay.
1.4.
Okay. Next, this interrogatory application has been filed for correction of the modification of the order dated 24/7/2023 passed by this court in WPC 1969 of 2020. As per para, next, as per para 28 of the said order, this court had relegated the petitioner, sorry, you are the petitioner, the applicant, who is the petitioner in this writ petition, to file an appeal before the industrial tribunal Dibrugarh if so advised. Post law. Next para. By referring to the provision of section 11 of the Industrial Disputes Act 11,
11.
comma, it is submitted that Industrial Disputes Act, it is submitted that under the prescription of section 11, comma, the appeal
11 AA.
11
AA.
A.
Small a, surplus.
Where the head office is situated.
Hmm?
Where the head office is situated.
Eleven A, I'm not finding, just give me that book.
Even A of Trade Union Act, no, sir. Trade Union Act.
Oh, Trade Unions Act, no, that's right. No, hold on. 11 within bracket 1 within bracket small a. The jurisdiction to entertain the appeal is vested with the labor court or an industrial tribunal. Full stop. The provision of full stop. Accordingly, it is submitted that instead of only referring to industrial tribunal everywhere, it would be appropriate that the applicant be also permitted to move the labor court in terms of section 11 within bracket 1 within bracket AA of the Trade Unions Act. Next paragraph. The provision of section 11(1) within bracket AA of the Trade Unions Act is quoted below. Next paragraph. Accordingly, as the prayer of the applicant is not objected to by the respondents or opposite parties, the prayer made in this interlocutory application stands allowed. Para 28 of the order dated 24/7/2023 passed in WPC 1969 of 2020 will now be read as follows. In this page 23, before the I am adding this appeal before the labor court or an industrial tribunal Dibrugarh, as the case may be, as per section 11(1)(a) of the Trade Unions Act. This recast para 28. This the order passed today, recasting paragraph 28 of the order dated 24/7/2023 shall be read together. So the interpretive application stands allowed. The book I am returning.
May I please, your lordship, my lord, order is at page 12, my lord, operative portion of the portion of the order against which the contempt petition has been prepared.
Not
my lord.
complied,
Page
not
12.
complied. Not complied.
Not complied, my lord. My lord, actually, on last occasion, on my lord, 31/3/2023, when the matter was listed, the standing council of the PNRD department was asked to obtain instruction, but on the next day, nothing was come, my lord. So may I pray that notice may be issued, my lord?
Notice are not issued.
Not issued yet, my lord, because on the first day when the matter came up before this honorable court, the standing council was asked to obtain instruction.
Okay. But Mr. D.P. Bora, counsel for the petitioner. Contempt. Notice takes steps within 2 days.
Yes, my lord.
Pendency of this contempt petition shall not be a bar for the respondent.
Page 10, my lord. Page 10.
Only one petition. Only one petition. The respondents to comply with the order of this court. Dated
Page
17/9/2021, passed in WBC 2668 of 2021.
Obliged, my lord.
42.
Wait, please, your lordship.
Yes,
Lordship, lordship, allow me 4 weeks time to file my affidavit.
pardon me,
4 weeks time to file my affidavit.
notice has not been issued, huh? Okay. You want 4 weeks time
4 weeks time.
to file affidavit, not to comply with the order.
No, sir. You'll have to comply, my lord.
Mr. J. Singh, counsel for the petitioner. Mr. S. Bora, counsel for the respondent.
So listen.
Praise for and is granted 4 weeks time to file affidavit in opposition in the matter. Next para. The continue, prayer is allowed. Next para. However, it is provided that the pendency of this contempt petition shall not be a bar for the respondents to comply with the order dated 1/11/2022, passed in WBC 5986 of 2022.
Okay.
Please start with Felix.
Forty-three.
Please do one. Lordship, notices were issued on this, but notices were issued on the last occasion, but the AD class is not received. Has not returned.
It went only on 16/8.
16.
Okay. Mr. J. Singh, counsel for the petitioner. As per office note dated 19/8/2023, notice was issued to the respondents only on 16/8/2023. Services awaited. List on 22/9/2023. Just before that, you write, just write. The learned counsel for the petitioner is granted liberty to collect the postal receipt number from the registry to submit postal track report prior to the next day for this. List on 22/9/2023.
44.
None appears for the petitioner. Contempt notice the steps within 2 days. And this shall not be allowed for the respondents to comply with the order of the court.
45.
Lordship, as per the Honorable High Court's order dated 26/4/2023, the court has directed the respondent number 2 to release the outstanding service dues, Lordship, but the respondents have not yet
Okay,
complied.
your
with the
name
orders. Lordship and Dekaraja.
and Dekaraja, Miss and Dekaraja, counsel with the petitioner,
Lordship, kindly
petitioners.
notice may be issued.
Sure. Contempt. Notice steps within 2 days. Pendency of the contempt petition shall not be a bar for the respondent, for the respondents to comply with the order of this court.
46.
It's AK Datta for the petitioner.
Non-compliance of order dated 15/3/2020.
It's same order.
Same order,
Next steps within 2 days.
you notice, my lord. Notice.
Issued. Take steps within 2 days.
47.
We have filed this IA. The matter is regarding about a penalty was imposed by the Assam Gramin Vikas. I was an employee. I am still an employee of Assam Gramin Vikas. I was holding the post of regional manager. In the meantime, my lord, there was some inquiry which was conducted. On the inquiry being conducted on 1/2/2023, my lord, a major penalty was imposed. Now, there was some reduction of my basic pay. That was the penalty which was imposed. Second, my lord, then another was that I was restrained from appearing in any promotional interview, test of the board. Now,
Yes.
this was moved before this honorable court, and there was an order which was passed at page 12 by this court in my IA, that is on 29/3/2023, where the court said that, yes, kindly see the operative portion of the order
12.
at page 15, 12.
Yes.
12 is the order, 29/3/2023. Kindly turn to page 15. Accordingly, page 15, the last paragraph, accordingly, it is directed petitioner be permitted to appear in the promotional interview test as may be conducted by the bank if the petition is otherwise eligible. However, the result of such interview test for promotion in
Seal
respect of petitioner be kept in seal cover and shall be subject to further orders to be passed by this court. Now, this petitioner is retiring in the month of November 2020. Page 16, there is a result which has been announced by them on 25/4/2023. This 2%, my lord, was promoted to the post of Assistant General Manager at page 16. Your lordship will kindly see 2%, one is Naresh Chandra Roy and another is Dilwar Rahman. Dilwar Rahman has retired. Now he retired. Dilwar Rahman. So one post is vacant. So what we are praying, now there is an order. Now one matter, one IA was filed before this honorable court. Your lordship has passed an order on 17th. But as the what proceeding, the minutes, because there are how this election has taken place, what is the proceeding, whether they have taken all relevant factors. So this IA has been filed. My lord will kindly see my prayer at page 10. Page 10.
Yes.
Your lordship would be pleased to issue appropriate direction towards securing the service carried by way of
promotion against the available vacancy. Now next, further your lordship may please to call for minutes of the selection committee, related records of perusal, so and so, so and so. So your lordship will call for the minutes records, how the selection was held. And one post is already been kept vacant. Well, we already, that one post is lying vacant. That person has already retired.
Yes,
My lord, I think record, my lord, we can submit our file the affidavit, my lord. And we can record, my lord. The minors also we can file, my lord.
because this was done after the order of this court. So whether you have considered his candidature,
My lord,
this promotion was done after the order of this court.
yes.
So whether you have considered his candidature,
No, my lord, he was allowed to appear in the interview and his still covered, my lord.
seal cover procedure has been done. Okay.
So we shall produce all these.
So they can produce it before the court. See how he has done it.
My lord, let
Minutes.
us be after 10 days time, my lord, we can file the affidavit along with that.
Only worried is that 20 November 2023 retiring. That's the only.
No,
If
he can always get post facto benefit.
Yes.
It can, notional benefit can always be given even if after he retires. But I am issuing a notice.
Yes.
Mr. D. Das, Senior Counsel, assisted by Ms.
S.
Sharma, Counsel for the applicant. And Mr. G. N. Savala, learned Senior Counsel, assisted by Mr. A. Setia, Counsel for the opposite parties. All the opposite parties. Next para. Issue notice on this interlocutory application. Returnable on 10 days, you said. Give a date, Mr. Saivala.
My lord. Yeah, I should. 4th September. my lord.
4th is a holiday.
Holiday.
We'll fix it on 8th. 2023.
Yes.
It's
You don't need extra copies, you have it.
my lord, that will do.
Next para. It is provided that on the next date of listing, the opposite parties shall file their affidavit and also produce the records relating to
Interview.
relating to consideration of petitioner for the purpose of promotion.
But that post should be kept vacant, my lord. No one should fill up. That post is
That
already.
my lord need not be, my lord, because this post, my lord, now held vacant, we have to advertise it. But we cannot fill it up, my lord.
But
Okay, what is the procedure? What is the post?
My lord, this is
Assistant General
assistant
Manager.
general manager.
Assistant
We cannot fill up the
It's
post. my lord.
not a promotional post.
It
It's
is
a
promotional
promotional
post. So we have to again advertise it.
So that's the only worrying, my lord.
Yes. No, that will not be filled up.
Yes.
Oh.
At least
They
I
will
can,
not fill up.
I can assure the
My
court, my
lordship
lord,
will-
that we shall not fill up.
Oh, okay. Next one is further that it is in exit of listing. The post of
Assistant general
Assistant
manager.
General.
Assistant General Manager of Assam Gramin Vikas Bank
Yes.
shall not be filled up without following due process of law.
Deeply obvious.
Okay.
Yes, Your Lordship. My lord, I am for respondent number 6. The copies of the writ petition with annexures not yet furnished to us, though there was caveat.
Give it. There was a caveat.
Yeah, caveat was bypassed and got the case listed earlier. However, we are not
How
on
it
that.
can be?
Let
No, but how it can be? What is your caveat number?
caveat number 2023.
You,
And it was filed on, my lord, 15/5/23. And WBC was filed on 17/5, 2 days later.
Mr.
My lord, we have sought.
Your name,
Cafe Ahmed.
S.A. Ahmed for the
Uh,
petitioner, counsel for the petitioner. You're giving copies, correct? In course of the day to day, you just go out and get it, given to the to Mr. M. Mahmood. Mr. Next para. Mr. M. Mahmood, the council,
For the respondent
has
number 6.
entered appearance for respondent number 6. And he seeks a copy of the writ petition. Mr. The learned counsel for the petitioner shall provide a copy of the writ petition to the learned counsel for respondent number 6 in course of the day to day. Mr. Hazarika, learned government advocate is present for respondent numbers
1 to 4.
1 to 4. Next branch. Service of notice on respondent number 5 is awaited. Next paragraph. The learned counsel, the respondent number 6 has brought to the notice of the court that the respondent number 6 had filed a caveat on 15/5/2023, being caveat number 440 of 2023. Full stop. It is noted with concern that although this writ petition was filed on 17/5/2023, comma, but the caveat filed by the respondent number 6 was not tagged when this writ petition was listed before the court on 19/5/2023. So therefore, the caveat has been bypassed. Full stop. Next, accordingly, let this matter be brought to the notice of registrar within bracket administration. We shall examine as to how the caveat filed by respondent 6 could not be noticed and tagged when this writ petition was listed. Next one. How much time you need? 2 weeks?
That is 3 weeks, well.
Okay.
That may be fixed, my lord.
We are not fixing a date because the service is to be awaited. The service was taken, the steps was taken only issued on 14/8. So if it is 14/8, we'll have to wait for 1 month. list on 18/9/2023, awaiting report of service on respondent number 5 and affidavit in opposition by the respondent number 6, as well as report of the as well as the registry's report as to how the caveat had escaped the how the caveat,
My lord,
how the document of the caveat was missed out when listing the matter.
we may be allowed to file an additional affidavit. We obtain some more documents.
You want to file an additional affidavit, then their affidavit will stop. You must know the sequence of submitting. After the order is dictated, after I've given them time to file affidavit, then you say, I want to file an affidavit. Inquiry. Land counsel for the petitioner. 6. Time to file additional affidavit to bring on record additional documents. If that be so, comma, there's no point directing the respondent numbers, the respondents to file their affidavit. Accordingly, filing of affidavit in opposition by the respondents is deferred till the additional affidavit is filed by the petitioner. This after
Yeah.
No,
Date may be given. In the meantime, we will file 2 weeks.
Mm, 11/9/2023. This one 11/9.
I filed affidavit of opposition today on this case condemnation. I think it is not in the list record.
Okay,
So, my lord, I need at least 3 weeks time to file reply. My client is residing in Lucknow.
affidavit in IA.
I on condemnation petition.
What is this IA for?
I for
IA was for
condemnation.
continuation.
You are
170.
seriously objecting to it?
Yes.
Yeah,
Because review petition has been filed. It is
No, I understand, but your objection is very serious or it
Very
can be
serious.
Very serious.
very serious. Okay.
My lord, serious in the
Because
sense, serious in the sense, what I understood, my lord. Serious in the sense there is no proper explanation and day-to-day explanation.
40 paragraphs,
One top day-to-day explanation.
1 to 40 paragraphs in I.
You know, on
So I have
one hand, they are saying,
every paragraph.
one hand, they are saying day-to-day explanation. On the other hand, they are saying, 40 paragraphs. So I have given day-to-day explanation.
Okay.
In fact, review has been filed against the order which was passed on the basis of a mediation order. As good as consenting order.
Okay, both sides are duly represented. Mr. S.K. Sharma and counsel for the opposite party,
Parties, both.
both the opposite parties, has submitted that he has filed an affidavit in opposition in course of the day today. The registry shall track and tag this affidavit on record. Next madam. Mr. A.K. Purkasto, counsel for the applicant. Grace for is granted. How much time?
3 weeks time, my lord.
2 weeks.
3 weeks. my lord.
3 weeks time to
It is
file
not well.
affidavit in reply in the matter. So this after 3 weeks.
My lord, obliged. I think it is the last item, my lord.